Second one, two. Mic check, one, two.
Yep, you good.
Mic check. 1, 2. Mic check. 1, 2. Four minutes? Yes, ma'am. 4 minutes.
Thanks all. Welcome back. Thank you for your continued attention to our important topic. We'll now proceed with our third panel. In the order in which they will speak, our panelists are Michelle Bishop, Disability Advocacy Specialist for Voting Rights at the National Disability Rights Network, Michael J. Pitts, Professor of Law at Indiana University, Cleta Mitchell, Partner at Foley and Lardner, John Fund, columnist for the National Review, Anita Earls, former Executive Director of the Southern Coalition for Social Justice, and John Merrill, Secretary of State for the state of Alabama. Ms. Bishop, please begin.
Good afternoon, and thank you so much for the opportunity to provide testimony today. I'm here with the National Disability Rights Network. We are a national membership association for the nationwide federally mandated system of protection advocacy agencies in every state, territory, and the District of Columbia. I believe that the impact of the Shelby County decision has been felt in every election since the Supreme Court handed down its ruling, and a number of my colleagues addressed the breadth of those issues today. So I wanted to use my brief time to focus on two particular impacts of the Shelby County decision that I feel are being felt very strongly in the disability community, and that's voter ID laws and the closure of polling places. If we take a look first at one of the most prolific consequences of the Shelby County decision, voter ID laws first, the Brennan Center for Justice found that 22 states introduced at least 39 pieces of legislation to impose stricter ID requirements in 2017 alone. Yet we know that voters with disabilities are less likely to have the proper ID required to vote. Rutgers University took a look at existing data from Pew Research Center and estimated that about 7.5% of people with disabilities did not have state-issued photo ID, compared with 4.8% of their non-disabled peers. And that difference is statistically significant. The U.S. Senate Special Committee on Aging and U.S. Senate Committee on Rules and Administration also took a look at barriers to voting for older adults and found that 1 in 5 citizens over the age of 65 do not have a valid photo ID, despite the fact that they made up 15% of voters in 2016. Proponents of voter ID legislation often characterize it as a matter of just leaving your home and going to get the proper ID to be prepared to vote. So I'd like to take a moment to address that. Brennan Center also found that 10 million voters live over 10 miles from the closest office that can issue the proper form of ID and is open more than 2 days per week. And I'd encourage the commission to take a moment to imagine that you're also a person with a disability, and your disability prevents you from driving to that office independently. So now you have to find another way to get the 10 miles. And like most Americans, you probably live somewhere where public transit isn't efficient. Or if it exists, it's not compliant with federal accessibility law, so you can't ride it. Let's assume you somehow surmount those odds, you get to the office and it's open. And now you've realized what most people with disability know, that many of those offices are also not compliant with poorly enforced federal accessibility laws. Perhaps you can't get in the door. Or if you found that the camera that they use to take the photo, that puts the photo in photo ID, is mounted permanently to a high counter and can't be tilted down to take your photo while you sit in your wheelchair. The idea that voters can simply leave their home on any given day and obtain the ID necessary to vote is one that just simply doesn't hold up in the real world. I'd like to take a moment to talk about polling place closures as well, because voter ID has garnered a lot of the attention that has been paid to these issues post-Shelby decision, but I believe that polling place closures are having a really significant impact on access to the vote, particularly for voters with disabilities. The Leadership Conference for Civil and Human Rights took a look at this issue and estimates that 868 voting locations were closed in 381 counties formerly covered by federal pre-clearance between 2013 and 2016. Arizona closed 212 polling places. Maricopa County, Arizona alone closed over half of its polling places in 2016, causing over 5-hour wait times for some of their voters. And Texas led the pack by closing 403 of their polling places. We've already talked about the inaccessibility and lack of public transit in the US, thinking about the distances that voters are being forced to travel when the polling places around them have closed, particularly voters with disabilities for whom those transit systems are often insufficient. But we could also talk about longer wait times and what a 5-hour wait means for a person with a disability whose disability prevents them from standing for 5 to 6 hours in order to exercise the right to vote. Does all of this equal an impact on voter turnout? I believe that it does. People with disabilities are overrepresented among those as well who are hardest hit by some of these laws. Rutgers University found that people with disabilities are more likely to be low income. Specifically, almost 1/4 of those with a personal income of $25,000 or below are people with disabilities. Rutgers also estimates that eligible voters with disabilities in 2016 included 5.1 million African Americans and 2.6 million Latinos, communities who are typically targeted by these discriminatory practices. Our voter participation is suffering as a result. Rutgers concluded that 35.4 million people with disabilities were eligible to vote in the November 2016 election. Yet in 2016, people with disabilities were registered to vote at a rate 2 percentage points lower than their non-disabled peers and turned out to vote at a rate 6 percentage points lower. That gap actually represents 2.2 million lost votes in the disability community. If we take a look at the longitudinal data that Rutgers University has been building, the gap in voter participation before passage of the Help America Vote Act was 12% between disabled and non-disabled voters. That gap dropped to 7.2% in 2008 and decreased again to 5.7% in 2012. But in 2016, the gap in participation for voters with disabilities actually increased to 6.2%. That means that for the first time in over 15 years, we're moving in the wrong direction in terms of voter participation of people with disabilities. I believe that Congress and the Department of Justice have a role to play in this. The Voting Rights Act, first and foremost, must be fully restored. It has been, federal preclearance specifically, has been our primary line of defense against voter suppression for 50 years, and it should continue to be so. I believe that effective federal preclearance prevents a maze of state-based litigation that causes fear and confusion for elections administrators and voters alike. Until the Voting Rights Act is fully restored, I believe the Department of Justice must stay vigilant in ensuring fair and accurate elections by exercising its full authority to enforce voting rights laws. I would be remiss if it did not encourage the Department of Justice to also fully enforce the Americans with Disabilities Act and its provisions for polling place access. The U.S. Government Accountability Office in 2016 found that only 40% of America's polling places had no barriers for people with disabilities. Only 35% of voting booths had no barriers for people with disabilities. The vast majority of America's polling places are inaccessible. I understand we're under a lot of pressure to make our voting systems accurate and secure, but we cannot disregard federal accessibility law. An election in which the results cannot be trusted threatens the health of our democracy, but an election in which voters with disabilities are denied access is not America. Thank you.
Thank you, Ms. Bishop. Professor Pitts?
I want to thank the Commission on Civil Rights for the opportunity to testify here today. Section 5 of the Voting Rights is an iconic piece of civil rights legislation, and its dormancy, created by the decision in Shelby County versus Holder, is a truly unfortunate event in the history of voting rights in the United States. The initial letter of invitation I received from the Commission to provide testimony presented several questions for consideration. I won't repeat those questions verbatim, but let me summarize their main focus. First, several of the questions were retrospective, focusing on what has already happened, particularly during the most recent presidential election. Second, the thrust of the questions largely related to issues of voter participation and vote denial, with examples of vote denial including things like restrictive photo identification laws. Third, because of the focus on the presidential election and vote denial, the questions centered around the impact of Shelby County at the state and federal level. While these areas are all genuinely important and incredibly worthy of discussion, for reasons I will explain in a few moments, I'm going to slightly reframe the discussion in 3 ways. And anyway, I'm a law professor with tenure, so I never do exactly what I'm asked. First, I'd like to focus prospectively on what the loss of Shelby County might augur going forward. Second, I'd like to focus on vote dilution, for instance, on redistricting, rather than on vote denial. Third, and perhaps this is my most important move, I'd like to focus on local governments rather than the state and federal level. After that, and this is something the Commission did explicitly ask about, I'd like to make a recommendation as to what the United States Department of Justice might do in the future in the realm of local vote dilution in light of the Shelby County decision. Looking prospectively, it is now 2018. The 2020 census is about 2 years away, and a new census means a new decennial redistricting cycle. Indeed, and this is quite amazing if you think about it, unless something dramatic happens to resuscitate Section 5, This will be the first decennial redistricting cycle since the creation of the one person, one vote doctrine in Reynolds versus Sims, where Section 5 will not play a role in the design of new redistricting plans. It's important to be mindful of the 2020 redistricting cycle because Section 5 has always had a major impact in those cycles. There's no doubt that Section 5 played a strong role in preventing vote denial through chicanery involving polling places, registration techniques, and such. But Section 5 has played an enormous role in preventing dilution and the retrogression of minority voters' ability to elect their candidates of choice. For example, the majority of Section 5 objections since 1982 came in the area of vote dilution rather than vote denial, and an outsized amount of those vote dilution objections involved redistricting plans. Moreover, while Section 5 played an important role in state and congressional redistricting, the impact Section 5 had on local redistricting was arguably even greater. Over the decades, Section 5 played a huge role in redistricting when it came to the design of districts for county commissions, city councils, school boards, and the like. As just a small example of this from recent years, take the objections that the Justice Department interposed between 2011 and 2013, dates that correspond with the most recent 2010 redistricting cycle. Of the objections interposed, nearly 2/3 of those objections were to local redistricting plans. Relatedly to points I've already made, almost 75% of those objections were to changes related to vote dilution, and only 20% of all those objections were to changes enacted by state governments as opposed to local governments. In my opinion, Section 5 has been absolutely critical in ensuring equal access to voting on the local level by preventing vote dilution. Again, this is not to say that vote dilution and vote denial don't happen on the statewide level as well, but the statewide level changes tend to be high profile, and often relatively well-funded entities will have the time, money, and incentive to bring litigation under the Constitution or other provisions of the Voting Rights Act. That's not always the case on the local level, where fewer resources typically exist. Indeed, aside from direct litigation costs, it may even be difficult to find plaintiffs ready and willing to bring a case on the local level because of the potential less tangible impacts local litigation can have on individual lives. So if historically there has been a lot of action at the local level related to redistricting, and we have a redistricting cycle coming up where Section 5 seems likely to be inoperative, is there anything that can be done? In my view, there is something that could and should be done by the Justice Department to help ensure that the 2020 redistricting cycle does not lead to widespread retrogression of minority voting rights on the local level. And I'd like to give the broad outlines of an idea here. My recommendation is that the Justice Department establish what I would call a local redistricting task force for the 2020 redistricting cycle. The Justice Department undoubtedly has an archive of just about every local redistricting plan adopted during the 2010 cycle. The department can and should systematically monitor and request redistricting plans adopted by local jurisdictions after the 2020 census. And the Justice Department can and should compare what the old and new plans do to minority voting strength. And let me emphasize that this should all be done in a highly visible and systematic manner. I think there would be two principal benefits to such a local redistricting task force. First, local governments who know that the department has its eye on local redistricting will be much less likely to engage in vote dilution because they know they are being monitored. It's a bit of an observer effect. Knowledge of the active observation will impact behavior. Indeed, it's what Section 5 did a lot to accomplish over the years, deterring the adoption of discriminatory changes before they even got off the ground. Second, the local redistricting task force will be able to, when necessary and appropriate, use litigation to ensure that vote dilution does not occur on the local level and that important gains made by Section 5 are maintained going forward. In conclusion, I commend the Commission for holding this hearing and hope that the Commission will also focus on the prospective issues related to vote dilution on the local level that loom large on the American voting rights horizon. Thank you.
Thank you, Professor Pitts. Ms. Mitchell?
Thank you, Madam Chairman and members of the Commission. I was going to say thank you for inviting me here, and I guess I do say thank you for inviting me here because I want to refer the commissioners to my testimony, which I have included in the packets, but I'm going to depart from my prepared comments because of some of the things I've heard here today. And I, as a citizen and taxpayer, am pretty troubled by, and I'm taken aback by many of the things that I've heard today. Because this to me is, the fact is that the commission is supposed to represent the thoughts and views of all Americans, and not just the professional grievance industry that has been on full display today. See, I did not realize until I came here that there's a well-oiled plan. I guess this is part of it, to try to reinstate, to reverse Shelby and to reinstate pre-clearance provisions for those states that we don't like and jurisdictions we don't like. And somehow that, I heard someone say that the reason the Supreme Court made the decision it made in Shelby was because to avoid they did it to avoid hurting some states' feelings. No, there's a constitutional construct. And that construct is, as the court said in Shelby, that all states and all jurisdictions are equal sovereigns. And they are not supposed to be, and the federal government is not supposed to pick and choose between favored jurisdictions and disfavored jurisdictions. And I heard one of the most amazing thing to me, this is perfect that this is on February 2nd, Groundhog Day, because it seems as though, as I said, the professional grievance industry simply can never, ever say, we've made a lot of progress. And in fact, 1965 formulas no longer should be utilized in any federal law or the actions of federal agencies. But I heard the most remarkable thing just a moment before we broke for lunch, when someone said that we should not look at minority voting patterns any longer. Really? That's what Section 5 preclearance was premised upon. Minority voting patterns. Now, it is true, they were more minority voting patterns in 1964 and 68 and 72. But the fact of the matter is, what I've heard, what I've realized sitting here today is that the grievance industry now wants to move from fact-based determinations to intent-based determinations. So now we're going to have legislation by mind reading, which I find pretty troubling and quite Marxist. Now, I cannot imagine, but actually it played itself out in North Carolina. I'm a registered voter in North Carolina. And I have read the decisions, I've looked at what happened. What happened in that case is exactly what the witnesses and apparently what this commission wants to do, which is to take this out of the realm of minority voting patterns and actual data, and to instead, we're going to work on intent. So here's what happened in the North Carolina case. That's exactly what happened. The trial court conducted a trial, heard witnesses, issued a 485-page opinion in which he painstakingly went through the evidence and the facts and addressed each and every one of the allegations in the plaintiff's complaint, and determined that under the facts, that minority voter turnout had in 2014 been better than it had been in previous years, with the law in effect at that time that was being challenged. When that case went to the Fourth Circuit gave short shrift to the facts and all at that 485-page opinion, and instead said, we're not going to look at the facts. We're going to decide that the legislature passed this law because they had a racially discriminatory intent. And the basis under which the Fourth Circuit made that decision was the fact that the legislature had contemplated, had sought, and considered the impact on minority voting by various proposed changes to the statute. Now, let me ask you this, ladies and gentlemen. Had the legislature not considered whether or not the statutory changes how it impacted various groups, what would you have said? What would all of these witnesses have said? They would have said the fact that the legislature didn't even consider whether this would have a dilatory effect on race, based on race, is a sign of discriminatory intent. So I would say that the industry, the professional grievance industry, on full display today, has moved the goalposts. So now we're not looking at data anymore. We're not supposed to look at data. We're now supposed to look at intent. And I would just come back to the fact that it's pretty clear to me. Look, I used to be a Democrat, then I was an independent, and now I'm a Republican. So I'm a walking party switcher. But I will tell you that I would bet that most of you believe, most of the people who've testified today, probably believe in their heart that with very rare exceptions, there are no Republicans who really aren't racist. They're really racist. Southerners, people who talk like I do, are racist. And so they deserve to have extra scrutiny and supervision. I think that it is important for this commission to stop and think about representing all of the people of this country, about acknowledging our successes, about looking at data. Let's look at I expected somebody to testify about 2016 minority voting patterns, but I've heard none of that. It's Groundhog Day. It's let's not change anything. Let's go back to the way it was, and we'll find new reasons. And if the data doesn't support it, well, we'll just think about reading the minds of the legislators and having judges read the minds of legislators. I think that's a very dangerous approach for a nation who prides itself historically and has been grounded in the rule of law. And to me, as a lawyer, as a citizen and a taxpayer, and as someone who supports the Constitution, I would urge this commission to return to the Constitution and the rule of law. Thank you.
Thank you, Ms. Mitchell. Mr. Fund?
Thank you. Thank the commissioners. Many people in this room have good motives and are convinced that voter ID laws and other measures to buttress the integrity of elections are discriminatory. Many others also believe that fraud is not a serious issue. Rather than fighting these battles over and over again like Groundhog Day, they should be working to ensure that everyone can easily obtain an ID. The U.S. Justice Department has spent an estimated $50 million during the Obama administration fighting ballot integrity laws. Various civil rights groups probably have spent an equal or greater amount. What if all that money had gone instead into real efforts to put an ID into people's hands? There is sharp disagreement over how many people lack proper identification. Former Ohio Secretary of State Ken Blackwell says that, quote, one of the most often cited factoids, something that should sound authoritative but is not fact-based, is the NAACP's claim that 25% of Black American adults lack a government-issued photo ID. Think about that for a moment. This would mean that millions of African American men and women are unable to legally drive, cash a check, receive government benefits, board an airliner, or participate in everyday activities of modern life, unquote. Hyperbole of this sort perpetuates the patronizing view that minorities are helpless victims. Critics say Blackwell doesn't understand how high the barriers are for some people who have ID or lack ID. But if he were really wrong, it is difficult to see why so few voters apply for a free ID in states with such requirements. This left-right stalemate breaks my heart. Former Presidents Bill Clinton and Jimmy Carter have released a very interesting statement that has an idea that might just end the stalemate. They want to add a picture ID to Social Security cards, which almost 90% of Americans currently possess. Carter said he would support this idea in a New York Minute. Bill Clinton says, quote, the idea behind this agreement is to find a way forward that eliminates error and makes the best possible decision that we can all live with. Let's give somebody something else to argue about. Let's give everyone an ID. The two former presidents were joined by Andrew Young, former UN ambassador and confidant of Martin Luther King Jr. Young said, quote, it is our obligation to make sure that every citizen has the ability to obtain a government-issued photo ID, and the Social Security Administration is ideal for making that happen effectively and efficiently, unquote. Social Security has 1,200 offices around the country. Adding a photo option for cardholders would cost just 10 cents a card, he says. 10 cents a card. Speaking recently, Young said voter ID was not a symbol of discrimination, but, quote, a freedom card, unquote, a natural extension of President Johnson's efforts to aid the poor and disadvantaged. Quote, in today's world, you cannot do many things without an ID. Ensuring people have one allows them to enter the mainstream of American life and would be a benefit to them. Martin Luther King III, the son of the civil rights leader, adds, quote, If we embrace the Freedom Card, we help marginalized citizens secure independence from predators and ensure them that our nation's most sacred right, that of voting, will be enshrined. My father used to talk about ending the silence of good people. I cannot emphasize enough the positive impact a free and easy to obtain photo ID, a social security card, would have for those who are marginalized today, unquote. On the other side of the political spectrum, many Republicans also see promise in a photo ID social security card, and I can provide a list. Let me add my own voice to those who urge policymakers to consider the Freedom Card as a way to bridge differences on this issue and to get back to fundamentals. Election law experts say more safeguards might be necessary to end identity theft. The Social Security Administration warns people they should, quote, not routinely carry your card or other documents that display your number, unquote, because someone illegally could use your number or assume your identity and cause a lot of problems. If we had a photo ID Social Security card, we would make it much harder for people to practice identity theft. So if both sides agree, why isn't the photo ID Social Security card already available? One reason may be the ingrained habits of groups who have so much at stake and have previously attributed positions which they are reluctant to retreat from. A spokesman for President Obama said in 2014 that the issue of the Freedom Card was being studied after he was visited by Martin Luther King III and Andrew Young. But sources say the idea was opposed by Justice Department lawyers who automatically oppose any voter ID requirement. Nationally, voter support for photo ID remains strong across all demographic groups. And in the presidential election in 2016, the last time a state's voters were asked on this subject, Missouri backed the concept with 63% of the vote. The Freedom Card has won over previous opponents of voter ID laws. I cite the Brennan Center as an example. Other liberal groups have recognized subsidiary benefits of the idea. Right now, the difficulty of opening a bank account without a photo ID is a huge barrier to disadvantaged people, putting them at the mercy of check cashers and payday lenders, which is an $11 billion industry. The Freedom Card would eliminate some of the worst barriers to poor people participating in our banking industry. In conclusion, Rhode Island Secretary of State Ralph Moelis, a Democrat, he persuaded his state's Democratic legislature, Democratic by 80% in membership in both the House and Senate, to pass a photo ID bill in 2011 to address problems he detected in voter fraud in Providence and other cities. It included extensive outreach efforts, and members of the Secretary of State's office went to senior centers, homeless shelters, and community centers to process free IDs. The law has been implemented smoothly, Moelis says, and he views it as a national model. Quote, when the day is done, my job as Secretary of State was to maintain the integrity of elections. Even if a state doesn't have an immediate problem with fraud, doesn't it make sense to take sensible precautions rather than wait for someone to abuse the system and then it's too late, unquote. That same thinking might apply across the country so that all citizens can become full participants in American life. Many on the left and many on the right occupy common ground on this issue. The vast majority of average voters occupy common ground in the middle on this issue. Voter ID laws improve the honesty and efficiency of elections. They can also, if we design them properly, empower people on the margins of society. Thank you.
Thank you, Mr. Fund. Ms. Earls?
Thank you, Madam Chairman and members of the commission. I really appreciate you taking up this important issue and coming to North Carolina. Thank you for the chance to tell you a little bit from my perspective of some of the barriers that we face here. I divided my testimony into looking at denial of access and then measures that make it harder to vote. And so let me start with the denial of access. Felon disenfranchisement is clearly the provision, in my view, that has the strongest disproportionate impact on African Americans across the country. In 2016, 6.1 million people nationwide could not vote because of a former conviction. 1 in 13 of African Americans is disenfranchised, where that's 4 times the rate of whites. It varies greatly by state. This is an issue where the rules are very different state by state, and the numbers of people disenfranchised and the disproportionate impact on African Americans varies a lot by state. But it also impacts voters in states that you might think have a more progressive or more open system. North Carolina automatically restores the right to vote once your sentence is completed. So you don't have to go through any process for clemency. All you have to do is re-register. Nevertheless, many people end up being disenfranchised by our felon disenfranchisement laws, in part because a lot of people just don't know what they are. And even as an attorney, I have said to voters, I've looked up online, you have completed your sentence. As a lawyer, I'm telling you, you're eligible to register and vote, and they don't believe me. They're scared, they're intimidated, they won't try to vote. But also there are people who don't know exactly when they're able to re-register. In 2016, the State Board of Elections did a study and identified 440 people out of the millions of North Carolinian voters who they thought voted when they had not completed their sentence. 13 of those voters in Alamance County are now facing felony criminal charges. They are being prosecuted as felons. Many of those 13 did not know they had violated any law until they saw their names in the paper as being people charged with a felony. There's some view in North Carolina that this is just not fair to people who are trying to get their lives back on track, trying to become part of society again. And I think one important lesson is that it really does matter to people to be able to vote. Often you'll hear people say, well, you know, the last thing somebody who has a conviction is worried about is voting. They want a job, they need to feed their families. But in fact, it does matter. It's how we define who we are as a nation and who we include in the us of we the people. And so it does matter to people. So in Florida, though, there's good news. Yesterday, a federal judge threw out Florida's clemency process, not because of the disproportionate racial impact or because of the way Florida's law originally came out of an explicit attempt to discriminate against African Americans in that state, but because the way the clemency is arbitrarily granted. The judge said if any one of these citizens wishes to earn back their fundamental right to vote, they must plod through a gauntlet of constitutionally infirm hurdles, no more. So there are some promising moves towards ending this, but it truly is an absolute denial of the franchise. Second, let me say a little bit about voter ID from the North Carolina perspective. When it is an absolute bar, it does deny access. When I was at the Justice Department from 1990 to 2000, our policy was you can have a voter ID requirement as long as you have a signature alternative, so that people who don't have an ID can vote. And in that kind of scheme, it doesn't disenfranchise people. But what North Carolina tried to impose on the eve of their voter ID law being tried in both state court and federal court was a reasonable impediment exception, and it didn't work. I need to tell you about Alberta Curry. She was a named plaintiff in our state court voter ID case. She first voted in 1956 when she had to take a literacy test and stand at the back of the line so that white voters could vote first. For her, it was a matter of personal pride to be able to vote first on election day. So she would go get in line and vote on election day. But she was born at home with a midwife, did not have a birth certificate. She spent a couple $100, and this is the daughter of sharecroppers, a woman who put cotton herself. She went and tried to get an ID, but without a birth certificate, she could not get a photo ID in North Carolina. In 2016, in the March primary, in the May primary, we said to her, there's a reasonable impediment exception now, you go ahead and vote. So our plaintiff, Alberta Curry, went to her precinct in Fayetteville, and when she got there, they would not allow her to vote. So she called us, and we had to encourage her, this woman who was standing up for her right to vote, to try to go back and vote again. We sent one of our lawyers down there who went with her, and you have in my testimony what happened. But basically, they again tried to turn her away, and it took an attorney standing next to her for her to be able to vote in North Carolina. So what we know from the data is that of the 2,371 provision ballots in that election, 1,419 were rejected. 34% of the ID-related provisional ballots were not counted, though 34% were cast by African Americans, even though African Americans were only 23% of registered voters. There was also a disproportionate impact on Asian voters. Only of all the provisional ballots cast by Asian voters in that election in North Carolina, 20.3% were because of no ID, whereas only 5.9% of all provisionals were cast for that reason. So it truly did have a disproportionate impact and denied the right to vote. In my testimony, I also talk about improper purges
litigation we had over the ways that people's voter registrations were not getting through from DMV, turning to making it more difficult to vote. Early voting restrictions limit access because they not only make it harder for when people can go vote, but we have same-day registration at early voting, and that's really the fail-safe mechanism that enfranchises the most people in the state. Let me talk just for a minute about Sharpsburg, North Carolina. In 2017, there was a hotly contested race between an African-American and white candidate. At the end of the day, the African-American lost to the white candidate by 3 ballots. But what we found out was that in one precinct that was primarily where African-Americans voted, they had 12 ballots in a precinct that 200 people voted at. So a whole bunch of people went to vote in the Sharpsburg municipal election and were not given ballots, were not allowed to vote. So the Democracy North Carolina has an exhaustive report that I've put in my testimony about all the problems that happen at the polling places on election day in 2016. And those are some of the people I hope that you'll hear from later on today.
Thanks very much, Ms. Hills. Secretary Merrill?
Yes, ma'am. I'm delighted to be with y'all. Thank you so much for having me. I'm excited to have the privilege to share with you some of the things that we have going in the great state of Alabama. When I became the Secretary of State of Alabama 3 years and 14 days ago, I made a commitment to our people that we were going to ensure that each and every eligible U.S. citizen, as a resident of Alabama, is registered to vote and has a photo ID. And the reason for that is because we want each and every person to participate at the level that they want to participate, whether it's just by voting or running for office or whatever it happens to be. So one of the questions you may ask is, how do we go about accomplishing that? First of all, we reached out to all 105 members of the Alabama House of Representatives, all 35 members of the Senate. We said, give us 3 locations in your district where you'd like us to go to conduct a voter registration photo ID drive. And when we got those and we started that process, then we reached out to all the probate judges in all 67 counties. We said, give us a can't miss festival, event or activity in your community where you want us to go to conduct a drive. So we've been to the Chilton County Peach Festival in Clanton. We've been to the Peanut Butter Festival in Brundage, in Pike County. We've been to the Peanut Festival in Dothan, in Houston County. We've been to the Tomato Festival in Slocum, in Geneva County. I was a grand marshal of that parade.
Did you bring anything with you?
And we've been to the Rattlesnake Rodeo in Opp,
You can leave that one behind.
down in Covington County. And we've been to the Magic City Classic in Birmingham, where Alabama State and Alabama A&M play every year. We think it's important to go where the people are, but we still weren't sure that we were going to reach everybody. So we reached out to the 2 most recognizable people in the state of Alabama. I asked them, would you please make a commercial for us, and would you allow us to use your likeness on posters that we can distribute all over the state of Alabama? So Alabama head football coach Nick Saban and Auburn University head football coach Gus Malzahn made those commercials for us. In 2016, we asked Deontay Wilder, who's a heavyweight boxing champion, and Charles Barkley, who's an NBA Hall of Famer, to help us the same way, and they agreed. This past year, we asked Jessica Proctor, who was 2017 Miss Alabama, and Dr. Mae Jemison, who was one of the first African-American astronauts, to help us promote our effort, and they did so. We still weren't sure after we'd gone through that entire process that we were reaching everyone. So in 2016, we made it where if you have a phone or if you have access to a computer, you can register to vote, because now in Alabama, there's an app for that. We feel like it's important to make it as convenient as it can possibly be for our people to be able to be registered to vote and to have a photo ID. Now, we have a number of people who still believe that there are some folks in our state who are discriminated against because they can't get access to an ID. Maybe they can't go to one of those mobile locations that I described for you, even though we go to all 67 counties at least one time every year. Maybe they can't go to those festivals or those events or those activities. Maybe they can't go to the Board of Registrar's office. It's open each and every day in all 67 counties throughout the state of Alabama. Every day that the courthouse is open, they're open and they will give them a free ID. So if those people actually exist and they would like to have a photo ID and they don't know where to go, we will go to their homes and give them a photo ID. We have actually done that on multiple occasions in different parts of our state because we feel it's that important to make sure that we're reaching our people. So your next question may be, Well, what does that actually mean? Let me tell you what it means. In the last 3 years and 14 days that I've been the Secretary of State of Alabama, we have registered 906,214 new voters in Alabama. We now have 3,342,124 voters in Alabama. Both those numbers are unprecedented and unparalleled in the history of the state. We want everybody to participate that wants to participate in the state of Alabama. And I've had people ask me, why would you tell folks that you'll go to someone's home? Or why would you do that? Because if you do it for one, you have to do it for everybody. You know what my response is? You're absolutely right. That's why I do it. Because sometimes I think in Alabama, we have to try harder. Because we have to show you that we're serious. We have to show you that we're sincere. We have to show you that we mean what we say when we tell you that we want each and every person to participate. So what does that actually mean? March 2016, we had the presidential preference primaries in our state. We broke every record in the history of the state for voter participation with more than 1.25 million people participating. November 8th, 2016, when we voted for president, we broke every record in the history of the state for voter participation with more than 2.1 million Alabamians participating in the general election. And in the special election that we just had, December the 12th, 2017, for the United States Senate seat that Doug Jones now occupies in Washington, D.C., we broke every record in the history of the state for voter participation with more than 1.3 Alabamians going to the polls. And not one instance in any of those situations has it been reported that anyone was denied the access to the franchise at the polls in Alabama because they did not have a valid photo ID. We're going to do whatever it takes to ensure that each and every person that wants to participate is eligible to participate. And if you have any specific questions for me about what we've done or how it relates to other things that have been introduced today, I'd be delighted to answer them. Because I'm excited about what we're doing. We're changing the standard in our state. We want everybody in Alabama that wants to have the same privilege to participate. And if I find one instance where that's not occurring, we are identifying those people, we're investigating them where it's warranted, we're indicting them, and we're prosecuting them to the fullest extent of the law. Thank you so much.
Thank you very much. Open it for my fellow commissioners for questions. Commissioner Dagway?
Mr. Pitts, good afternoon. How are you? Could you speak to us for a moment about under what authority DOJ would obtain the redistricting plans in your proposed model? And do you contemplate that to be a nationwide effort or something less than that?
Thank you. Now you're going to make me expound upon my nugget of an idea. I can't say that I thought through every single detail of it, but I would imagine that under most of the public access laws in most states, if you make a request for information, you can get it. Indiana, for example, I can make a request and I can get whatever information I want from a public entity. I can't imagine that the Justice Department wouldn't be able to do the same. But if we needed to pass a law to do that, then let's pass a law to allow the Justice Department to get those records if necessary. The second part of your question was?
Yeah, so, and based on your expertise in this area, I take it it's not just the plan, but in order to assess the impact of a redistricting plan, there's certain underlying data that's necessary as well?
Yeah, that data is generally on CDs from demographers who draw the plans. It's not that hard to compile this information.
Okay, and is it your understanding that the DOJ would have the capacity to analyze nationwide every local redistricting plan?
That's a question that I could not answer because I haven't been at DOJ for about 12 years now, and I don't know exactly how much they have in resources to do that. I know that it wasn't a problem to do the Section 5 states, and I would say actually that you'd probably want to concentrate on the Section 5 states, at least initially, and there may be other places as well outside of the Section 5 states. But whether or not you would need to do it across the nation, I don't know.
Thank you. Ms. Earls, we heard a little bit about what the relevance of contemporary intentional discrimination may be, where courts find that various state legislatures or perhaps local ones have acted with the purpose of discriminating against minority voters. Could you help us understand why that might be relevant to assessing whether or not we still need vigorous Voting Rights Act protections?
Well, I think I would take, first, make it clear that the finding of intentional discrimination is based on facts. It's not mind reading. It's based on statements that legislators made at the time. It's not based merely on the fact that legislators looked at racial data. It's based on the fact that once they had that racial data, they excluded all forms of ID that disproportionately were held by African Americans and allowed as permissible ID all forms disproportionately held by whites. It's not just that they looked at racial data, it's then what they did once they had that racial data. So that I think the Fourth Circuit's finding of intent was based on in that particular case, was based on the totality of all the evidence that they had about the law at issue. It seems to me extremely important to the enforcement of the Voting Rights Act. The 15th Amendment is, the Voting Rights Act is enforcing the 14th and 15th Amendments, and they are designed to eradicate intentional discrimination. It would be an anomaly if we were to say somehow that impact evidence is more important than intent evidence. I think they're both important, and they, I think that sometimes the Supreme Court has had to wrestle with the question of, if you have discriminatory intent but not discriminatory impact, what should you do in those circumstances? But certainly, if you have a law that a court, after looking at the evidence, finds was intentionally designed to discriminate against a certain group of voters, that's the fundamental thing that our Constitution says the government is not allowed to do.
One further question about your experience in North Carolina. I take it that there has been a history of voting discrimination in this state. Is that fair to say?
Well, absolutely. If you look at the Thornburg versus Jingles case, there's a whole catalog of the history of explicit legal provisions that were intended to discriminate against African Americans historically. But then you look more recently at, it's not just the voter ID law and the vote suppression law, but a three-judge panel unanimously found that the legislature intentionally drew racially gerrymandered 28 legislative districts. A different three-judge panel unanimously found that the legislature racially gerrymandered 2 congressional districts. So there's a recent, it's not an ancient history, there's a post-2011 history of courts finding that this legislature is intentionally, in matters of respecting voting, is intentionally discriminating against African-American voters.
The reason I ask is because I'm trying to understand the concept in Shelby County that spoke to the need for a demonstration of contemporary evidence to justify remedial measures.
Right.
And in a situation in which you can demonstrate a certain amount of continuity in some places, I'm trying to understand what the difference is between the findings that you see today and those findings that happened a generation ago. Is there to a voter, does it matter if your parents were discriminated against in a redistricting plan in 65 or 1970, and today you're being discriminated against in a redistricting plan in North Carolina? What's the difference?
I don't see a huge difference. I see a continuing pattern of lawsuits, lengthy, costly, time-consuming lawsuits being brought, the legislature changing the law a little bit, and then having to bring another lawsuit. Immediately after the Fourth Circuit's ruling was upheld in the Supreme Court by dismissing the appeal, some legislators said, well, we'll just pass a constitutional amendment to have voter ID. We'll just pass these same laws a little bit differently. So this whole pattern that initially led to Section 5, we see it being repeated here in North Carolina. And we see young people going to the legislature, demonstrating and being willing to be arrested and go to jail because they feel like their right to vote is being taken away. That doesn't seem all that different to me.
Well, one last question. Ms. Bishop, do you have particular suggestions under the aegis of the Voting Rights Act or in some other way that the nation could do a better job to make voting accessible to people with various types of disabilities. And I was interested in your point about the accessibility, the percentages of polling places that are accessible to persons with different types of disabilities. Do you have a sense about how DOJ plays a role in determining whether or not polling places are accessible?
Absolutely. The Department of Justice is responsible for enforcement of the Americans with Disabilities Act. The accessibility provisions, particularly architectural accessibility of polling places, falls under the ADA. A properly enforced and overseen ADA would not allow these types of things to happen. First and foremost, I think the Voting Rights Act is important, and Section 5 of the Voting Rights Act was important because it facilitated that sharing of information between jurisdictions and the Department of Justice so that we had a sense of what was happening and why these things were happening that helped us to make informed decisions about those types of things. Access to the vote for people with disabilities in the United States is largely a patchwork of several pieces of legislation. That's why I bring up the Voting Rights Act, the Americans with Disabilities Act, the Help America Vote Act. All of these work in concert to ensure that people with disabilities are not denied access to the vote. So what we really need are fully enforced, fully restored, and strong pieces of legislation that are working in concert to make that happen.
Thank you.
Commissioner Harriet?
I just have a tiny point of clarification for Ms. Earls. You mentioned that the state legislature had rejected the IDs that African Americans disproportionately had. Which ones are those?
So the evidence at the trial and the evidence as cited in the Fourth Circuit opinion was that student IDs, and I'm not going to remember whether there was some other form of government issued IDs. It might have been state employee IDs. The evidence showed were disproportionately held by African Americans, but were not in the law as permitted forms of ID.
Thank you.
Ms. Bishop, I'll follow up on the last set of questions you were asked. I appreciate your point that full and effective federal enforcement would be helpful to ensure access to the right to vote for people with disabilities. But we are now 50 years after the Voting Rights Act and 27 years after the ADA, and what you described is a majority of places not accessible. We've also been hearing in the panels today about certainly vagaries in the focus of DOJ enforcement with respect to voting rights. I wonder if you think there is a foreseeable future in which you would see sufficient federal enforcement to allow for closing the gap that you described. And if so, terrific, please describe. If not, do we need a different law? Do we need something else to incent a way to make sure that those gaps don't persist?
I think it's possible, but I think the tail end of your comments sort of make it clear how that's possible. Some of this extends beyond DOJ, whose role is really primarily enforcement. I think that Congress has a responsibility to make sure this is happening as well. I think state and local elections administrators are in desperate need of funding to help update polling places and to help update voting equipment to make sure that it's both secure and accessible as possible. I'm glad that we're having a national conversation about that, but if we're not willing to put dollars behind it, then it's not going to happen well in terms of security or accessibility. I think it's really time to start having really practical conversations about what that means. I think that we need to continue to support the existence of the United States Election Assistance Commission that has a vital role to play in this process. And I believe that we have to start having very realistic where the rubber meets the road conversations between voters with disabilities in the accessibility community and the security community about how we're going to make both of those things happen. Often when we have conversations about vote security, which is clearly a primary issue in the world of elections right now, we fail to talk adequately about accessibility. If we're talking about reverting to systems that required much more an ability to hand mark a paper ballot, which is really what we've been talking about over the course of the past year, we have to talk about how we're going to make that something that's accessible for all Americans. We cannot sacrifice one for the other. Our elections have to be accurate and secure, but they also have to be accessible to all Americans. because that's what we do in America. So I think that this issue is much larger than just the Department of Justice or just the pieces of legislation we have in place right now that protect voters with disabilities. We have to start thinking practically about how we're going to bring all of those pieces together. I think it requires funding through Congress, and I think it requires the leadership of the Election Assistance Commission to make that happen.
Thank you. We have two members of the Election Assistance Commission on this commission, so I'm sure they appreciate your plug there as well. Secretary Merrill, I wonder if you could respond a bit to what Ms. Bishop was just saying. You have described frankly inspiring and laudable commitment to actually making sure that everyone in the state of Alabama could have access to an ID to be able to vote. What would it take for you and your state to make sure that all people with disabilities would be able to access the polls, and what would it take for you to make sure that other impediments to voting receive the same level of scrutiny that you described with respect
Yes,
to
ma'am. I
IDs?
think it's very, very important to ensure that people are able to go to the place where they're supposed to participate and to be able to do so when it's convenient for them. Some people would choose to participate in the absentee process by applying for an absentee ballot and doing that from the comfort of their home. We're trying to make that easier. We're also trying to make that more secure. But if they want to go to a polling site in Alabama, those sites are determined by the probate judge and by the county commission in each individual location. Some of those are not as convenient as others. But what we have to do is we have to work within the local community to ensure that we're going to a location that is safe and that is secure, that enables every person to gain access. Now, I think one of the problems that we had with the Help America Vote Act was that when information was introduced about what those resources could be used for, there was not proper training given to certain entities in the state to understand what needed to be done as a priority with those resources. One of the things that we saw when we took the position as Secretary of State was that we had people that would actually use those resources to pave a parking lot at a particular building. Well, that may be necessary, but if that parking lot is also being used as a parking lot for a ball field, a lot of other times during the year, they may be trying to use those federal dollars to pay for something that didn't need to be done with those federal dollars because the community could have gotten involved more, the municipality or the county. But we've got to make sure that we're more discerning about how those resources are used. But I think there needs to be a greater commitment from the local community and working with the local election administrators to ensure that we've got the best locations for those polling sites.
Thank you.
Yes, ma'am.
Commissioner Nurse? Oh, I'm sorry, Commissioner Yaki?
Thank you very much, Madam Chair. It's great when we have a Secretary of State who's here because then we can sort of ask some really on-the-ground questions. I have a question about Alabama's inactive status program. Can you describe a little bit how that works and what happens if a voter who actually has a history of voting but somehow
Yes, sir.
moved to that?
Yes, sir. As a matter of fact, for the first time since the law was passed in 1993, Alabama is fully compliant with the National Voter Registration Act, and we're also very excited about that. One of the things that happened in our state was that we realized they were not following the rules and procedures that were established according to the law when it comes to declaring that someone would be listed as inactive. I think that's a very inappropriate term to use because of what we're actually going through and describing here. The Constitution, the Code of Alabama, the laws that have been passed in Washington would have indicated that this exercise begins in January after the next federal election for president occurs. And so it occurred in January of 2017.
Mm-hmm.
So there were a number of people who went to vote in the primary in August of 2017 for the U.S. Senate election that were indicated as being inactive. They were moved to the inactive rolls because of the procedure that was prescribed and we fully adhered to that said this is how we contact our people. And so we actually had to mail out a certain number of cards to a certain number of voters. And that number that got the first mailing at the time, we had 3,309,899 registered voters. When that occurred, we mailed a contact card as described by the law that was approved by the Justice Department. We went to Washington and had it approved. And that procedure meant that the card could only go directly to the voter, but not follow the voter according to the postal service and how they would normally send a bill or
So
another.
it was non-forwardable, in other words?
No, sir, not affordable. And so we had 416,000 voters, 416,632 voters that received a second mailing, which was described as going to follow the voter and indicate where that individual is supposed to be. After we received 80,000 or so responses from that mailing, 340,162 voters were then moved to the inactive list at that time. Now, we had people that would go vote in August for the U.S. Senate special election, and they're saying, I'm not inactive. I always vote. The first call I got was at 8:32 a.m. that morning, and it was from Congressman Mo Brooks, who was a candidate for the U.S. Senate seat. And he said, John, we got a problem. I'm listed as inactive. My son's listed as inactive. My daughter-in-law is listed as inactive. Long story short, what happened there was Congressman Brooks would not let it rest. We actually sent him a copy that day of his image of his postcard that was returned to our office. But 2 days later, he didn't make the runoff. He went to the post office, and the postmaster told him, after he investigated it, that the route carrier went to his home, did not deliver it because it said Morris Baker Brooks Jr. He thought that was his son who had moved out of their home, and he didn't deliver any one of them.
But
So that was a
Congressman Brooks was
concern.
able to vote, correct?
Oh, yes, sir.
So,
But he had to vote a provisional ballot.
So he had to do a provisional ballot, but
Yes, sir.
you do allow a provisional ballot
Oh,
in
yes,
that
sir.
instance? But is it, under law, is it required to be a provisional ballot, or does it have to be, I mean, why does it have to be a provisional ballot?
Well, it
if
depends on the
they-
situation. If someone can indicate, and that's another thing about our voter ID requirement. When people actually go to vote, one of the things that our law allows is that if two election officials, poll workers or otherwise, can identify who you are, then you're able to vote just as if you had your regular ID that's described. And we have 10 different forms of ID that are available to be used. And again, I don't like the term inactive that we were using, and we're trying to get that changed in our law so we won't use that, because it basically just means you need to update your information. You can do that electronically, you can do that in person or at the polls.
And if you update your information at the polls, does your vote count?
Yes, sir, you can vote and it will count that day.
Okay, thank you.
Yes, sir.
Ms. Earls, you're looking like you wanted to get into that exchange.
She's just really engaged in what I'm saying.
It was fascinating. It does occur to me that there's obvious room for mischief if two poll members don't want to identify somebody as an active voter, using the term as it exists now. What are the steps you can take to try to avoid
Well,
that
they have to
issue?
sign an affidavit if they do that, indicating that they recognize this person. And we have not had any instances that have been reported to us where an individual went to vote. And I already shared it with you earlier in my testimony when I said that we've not had anybody turned away since this law has been in effect, requiring a photo ID requirement. So that instance has not happened where someone would be discriminated against because somebody didn't like them.
Okay.
Or because they weren't interested in allowing them to participate.
Thank you.
Yes, ma'am.
Commissioner Osaki.
Thank you. I want to thank Ms. Earls for mentioning Asian Americans. My first experience with what was happening with the voting rights in Asian Americans was actually Alabama, Bayou La Batre, Alabama, where there was a Vietnamese American running. There's a fishing community there. And because he was running, the election officials decided that they were going to challenge every single Vietnamese American voter, assuming that because they were Vietnamese American, they probably could not be a citizen and therefore were trying to vote fraudulently. The Department of Justice intervened, and the first Asian American was elected in Alabama. So it was had a good ending. I wanted to ask, because we had a lot of testimony about North Carolina, and you mentioned the fact that Asian Americans had been disproportionately impacted. Weren't there also findings by the court about discrimination against Hispanics in terms of how they decide which kinds of not just ID, but also what kinds of other cuts and changes they would make to the voting system in North Carolina?
Yes, there were Hispanic plaintiffs in the case, and there was evidence that that similarly to African Americans, they disproportionately did not have some of the types of ID that were not allowed as permissible ID. I believe there was also evidence of other types of discrimination against Latino voters that was part of the history of discrimination in the case, not necessarily directly tied to the law that was being considered. But Alamance County, when I mentioned in my testimony where these 13 voters are now being prosecuted, is also a county where the sheriff decided, and this is several election cycles ago, but decided to take the voter rolls and knock on the door of everyone with a Hispanic surname to confirm that they were actually citizens. And when he announced publicly that he was going to do that, obviously it caused a lot of fear and was intimidating. And the Justice Department did get involved, and I think that there was actually ultimately litigation that was generated by DOJ. So there was evidence in the case of past discriminatory actions in the state involving Hispanic voters.
Thank you. And Ms. Bishop, I also want to ask you about Section 208. Most people, I think, when they think of the Voting Rights Act, don't know what 208 is, and so maybe you could give a very brief explanation and how that works in terms of helping people with disabilities. And I would like your thoughts about how well it's been enforced, how well DOJ has done outreach and educated local election officials about what their responsibilities are under that act.
Absolutely. Section 208 of the Voting Rights Act is not often spoken about, although it is a part of the Voting Rights Act that applies directly to people with disabilities, guaranteeing you the right to assistance at the polls if you need someone to help you cast your ballot, anyone of your choosing, of course, other than your employer or your union rep. I think that not a lot of attention is paid to Section 208. I don't know that it is being particularly vigorously enforced. I also think that instances of denial of the right to assistance are going underreported. I don't know that our state and local elections officials are always particularly versed in this, or if they are, it's not necessarily stressed in the training that we're given to our poll workers, which is really where this issue comes into play. When you go to vote on election day and it's the poll worker there making the determination of whether or not they're going to allow someone to assist you, I think it goes underreported because I think that the authority figure of the poll worker, who may or may not be correct in what they're telling you, is very intimidating to some voters and makes them question if they do know whether or not they have the right to this assistant. We do get reports from voters who say, I brought someone to help me vote, and I was told I can't do that. I have to have one Democrat and one Republican poll worker help me, and that's the only way this can be done. Now, that can be done, but you do have the right to bring someone with you. So I think we have misinformation and miseducation all around. I think that DOJ can be helpful in that regard, but I do think it also starts with making sure our poll workers are trained to understand the rights of voters with disabilities and what type of accommodation they're entitled to when they come to the polls so that we can prevent things like that before they happen. I think that voters should also not be afraid to come forward and report these types of things when they're happening. Earlier today, it was mentioned that some of the organizations here, and mine is involved with it as well, run hotlines to assist voters. I would hope that voters would take the step of making that call, if nothing else than to verify whether or not they really do have the right to this type of assistance so that we can prevent that kind of thing going forward.
Thank you. Mr. Pitts, one of our earlier panelists made the statement in his, at least his written testimony, I can't remember if he also said in his oral testimony, that no one can rationally claim that there's still widespread official discrimination in any of the formerly covered states. And also someone else testified that the success of in their written testimony, that the success of Black elected officials in North Carolina shows there's no pervasive or rampant discrimination going on. Do you have thoughts about that?
Yeah, I mean, both of those are very loaded comments. My concern is going forward, what's going to happen in a world without Section 5, particularly at the local level. There's going to be an opportunity in 2020 for every entity that has single-member districts, many of which are in the formerly covered Section 5 states, to legitimately change their lines. They don't have to come up with an excuse to do so. They will have to, because of the rules governing one person, one vote from the Constitution. And I see the potential for some serious backsliding of districts that allow minority voters to elect their candidates of choice at the county commission and school district
I'm going
level.
to cut you off just
Sure,
because actually
absolutely.
redistricting is not in the purview of this hearing. So
Okay.
as fascinating and as challenging as I think all of that is going to be. So I want to see, Ms. Earls, do you have any response to those earlier statements?
So on the question of, does the success of African-American candidates for office in North Carolina demonstrate that there aren't any problems with voting? I have a couple of responses. One is, if you look across the board at all elected, so not just state legislature, but all elected offices, we actually still don't have parity in numbers. But more importantly, the Voting Rights Act is about the rights of voters. And the question is, do African Americans, do Hispanic Americans, do Asian Americans in the state have an equal opportunity to participate in the political process? That's what we have to evaluate. And there's some election of people of color is some indication, some measure, but it's not the full picture by any means. And the real question is, is our election machinery equally open to everyone?
And just one final question. So we have a big election coming up in 2018. Unfortunately, we didn't have anyone from the Department of Justice currently testifying today. I'm wondering what your advice would be to what they need to do to make sure that voting rights is being protected in the 2018 election.
So they have enormous resources, both in terms of the observer capacity that they can, and letting communities know if you anticipate there's going to be a problem, you can contact us and we can evaluate whether or not an observer is justified. But then all of the U.S. Attorney's offices, they all can be trained up even better. They all get memos at election time telling them, here's all the federal election laws, here's what to look for, here's what voter intimidation might look like, here's what you can do as a U.S. attorney. But a more vigorous effort working through all of the U.S. attorney's offices, I think, could be very useful.
And Secretary Merrill, since you are coming from the state end, is there anything that you think is helpful that the Department of Justice could be doing?
Well, I think that an intentional effort by the DOJ to make sure that people understand that they're available for support is always important. I think one of the things that we inherited when I took office was the perception that the Justice Department under President Obama was not as friendly to our state as a Republican administration might have been. I think there are a number of states in the union now who feel that a Justice Department under the leadership of Senator Sessions, who's now the Attorney General, and under President Trump will not be as helpful as it could be otherwise. I think whenever those situations are identified, they need to be publicly exposed and introduced so people can understand what needs to change in order to make that positive interaction occur. And I think just being open and willing to work with other people, we actually found members of the Justice Department before President Trump was elected to be very helpful to us because we wanted to work with them and we expressed that to them, and whether it be at the U.S. Attorney level or whether it be directly with Justice. And so I think that's extraordinarily important.
Commissioner Harriet?
Thank you. The name of the panel is voter access, but the flip side of that is making sure that non-citizens, someone who is not eligible to vote, doesn't vote. Because if your vote is canceled out by the vote of someone who's ineligible to vote, then you're being denied the right to vote. And Mr. Merrill, maybe you'd be the first to comment on this, but I'd love to hear from any of you, Ms. Mitchell, anybody. Um, I- What's the right way to make sure that only citizens are voting? What does Alabama do to make sure that someone who is not a citizen, and I don't mean to suggest that someone who votes who is a non-citizen necessarily is aware that they're breaking the rules. I know that when these issues come up, sometimes the defense is offered that, well, I didn't realize it. I went to the DMV and they gave me this and I thought I was supposed to vote and I did vote. What's the right way to deal with
Well, and
this
you know,
issue?
one of the first things I said when I shared with you what my goal was, which was to ensure that each and every eligible U.S. citizen that's a resident of Alabama is registered to vote and has a photo ID. I think that's very important. And really, I mean, somebody may laugh when I say this, but it's no different than me saying, well, I'm going to go to North Carolina and I'm going to vote for your governor, I'm going to vote for your U.S. senator today, but then I'm going back to Alabama to be a permanent resident. Nobody would want that to happen. Nobody would want somebody in the Lions Club to vote for the JC's president or in the Rotary Club to vote for the Exchange Club president. That's just not the way that you do it. And no individual that lives in our state that is not a resident of our state and not a citizen of the United States should not be participating
So
in
how
our
do you do it?
elections.
How do you make sure that
So
works?
we have to vet each and every application that comes in by our board of registrars to ensure that the information that's being shared is accurate, complete, and up to date. And if that requires visiting, if it requires the involvement of law enforcement, to have deputies when they're out surveying to determine whether or not someone actually lives at this location, to check information in the records that have been introduced to us, all of those things are very important. And it's a process and a procedure. It's not something that has to be done the same way each time because each individual application can be different.
But you could have someone who's not a United States citizen, but they live in Alabama. They're
Yes,
not
ma'am.
entitled to vote.
And we encourage that. And as you know, one of the things that we just announced recently was the relocation of a brand new facility, Toyota and Mazda, with a joint partnership. And we're going to have a lot of folks coming to Alabama that are not citizens, but they're not going to be able to vote unless they obtain citizenship. Now,
How do you document that?
there are a number of ways to do that, but one of the things that we are able to use, especially with our driver's license, is if you're a foreign national in Alabama, then on your driver's license, there's a capital F and a capital N that's placed here. Since this is the primary form for 95%, primary form of identification for 95% of the people in our state, it's very easy to use this as a tool that will enable us to determine your citizenship first and foremost. But most people, when they go to register to vote for the first time, or when they go to get their driver's license for the first time, use their birth certificate. So it's automatically recorded and documented, and it's already in the database.
So, well, if somebody else has a comment, that would be good.
Well, one of the earlier panels this morning had to do with, or some of the witnesses were testifying about enforcement by the Department of Justice. And as the Commissioner points out, it is a felony for someone who's not a citizen to register to vote in a federal election. It is a felony for someone who's not a citizen to cast a vote in a federal election. And I would argue that the Department of Justice, if we're talking about enforcement of federal law, that they should actually take steps to notify people, to make it clear that it is still against the law for non-citizens to register and non-citizens to vote. What happens if there's ever any effort to let people know about that law? The very industry I was talking about earlier, cry out that that's racist. It's racist to tell people that it's against the law if you're not a citizen to register and vote. There was a lawsuit about whether or not a state was allowed to put on its voter registration form, "Are you a citizen?" Now, I think that these things are preposterous. It is preposterous that we're having an argument, that we argue about enforcing the law. If you don't like the law, see if you can get it changed. But the fact of the matter is, I think most people in this country agree with the rule of law that says only citizens should decide our elections. And the only way we're going to actually enforce this is if we put it on forms and people testify under penalty or test under penalty of perjury, and we advise people and educate people that only citizens have the right to vote and have the right to register to vote. And to me, that is the rule of law that this commission ought to be about, being certain is being enforced and that the American people are being positively told about those laws.
We have a great debate on immigration right now. One of the things that's being discussed is a path to citizenship for the Dreamers and others. Clearly, people value citizenship. They think American citizenship is important. Well, I think there's been a cruel trick played on some people who are waiting for their citizenship. One of the Secretary's colleagues had to resign in Pennsylvania, had to resign his office after a scandal last December. The scandal was that for many years, the Department of Motor Vehicles was renewing people's driver's licenses on a touchscreen, and people who had a driver's license and were here legally, they were legal residents or had a green card, were presented with a screen that said, "Do you wish to register to vote?" with no other explanation. Many people assume if I'm asked a question, that means I can say yes or no. So many people said yes, and they registered to vote. Some of them went on to vote. Public Interest Legal Foundation is finding specific examples of how many going county to county. Well, immigration attorneys, when they prepare people for citizenship proceedings, have to ask their clients, is there anything that you've done while you've been in this country that may be a barrier to becoming a citizen? And if they answer truthfully, oh, I'm registered to vote, or the lawyer asks them, are you registered to vote? This is standard legal procedure. Well, that presents a real problem. So all over this country, people are being forced to go to county registrar of voters, and we have examples of this from Virginia and New Jersey and various other places, and they've had to ask to have their name removed from the registration rolls. And in many cases, they've actually voted in more than one election. That is a cruel trick that is being played on them by either incompetent bureaucrats or some voter registration groups that perhaps are not as scrupulous as they should be when they're signing people up, because they are putting their future citizenship as Americans in jeopardy by doing that. And the scandal in Pennsylvania is not a small one. The best estimates from the legislative committee looking into this are that 100,000 people are involved in one state. These people have their potential citizenship as legal residents jeopardized. So we have to take care of this, not just to make sure non-citizens don't vote, but to protect the rights of legal aliens in this country so they don't lose their right to become citizens because they've inadvertently or advertently committed a felony by voting and registering to vote.
I think our last question for this panel will be from Commissioner Degoy.
Yes. Mr. Merrill, are you aware of a rash of non-citizen voting in Alabama based on your years as Secretary of State?
No, sir. I would like to add something, though, if I may, and just so there's a clear understanding of this. Earlier today, on a previous panel, it was introduced that an individual believes that there are 118,000 people in our state that should be registered to vote that are not registered to vote and that do not have adequate IDs in order to be able to participate in the process. I've told that individual before, and I'm introducing this to the panel now, that if they will tell me one of those individuals' names, I will call my office when I leave here today, and they will go to their house and give them a photo ID. I want to make sure that that's clearly understood. I also want to make sure that everybody understands that if that indeed has occurred with anybody, that we're going to make sure that we take care of that. Because another thing that was not introduced in that panel was about the voter ID lawsuit that had been filed against the state of Alabama. And one of the reasons it was not introduced is because 3 weeks ago, yesterday, it was summarily dismissed by the federal judge in whose court it had been introduced. And that judge indicated that because we were doing what we're doing with our ID, that if other states in the union followed this, we wouldn't be having the concerns that we're having throughout the union.
Thank you.
Yes, sir.
Mr. Pitts, there's been a lot of talk about the importance of taking a local view, or what was lost after Shelby County, in terms of understanding what's happening at a local level compared to the more publicized statewide types of election laws. Can you help us explain, based either on your experience as a DOJ lawyer or through your teaching, why the DOJ under the old regime had a special advantage of being able to have eyes on all of these local voting changes, and what has been lost in that regard?
Yeah, I mean, it was systemic. the local governments knew they had to deal with the Justice Department, and they wanted to make sure that they complied with the law. And so there was a built-in incentive for them to protect minority voting rights. And that built-in incentive is gone totally. And so, I mean, without it, we have no idea what's going on. I don't know of any systematic reviews that anybody has done of voting changes on the local level since Shelby County's decision. And we should be tracking that more. And DOJ just had the resources and the power to do that tracking.
So actually, Commissioner Arasaki, you will have the last question since we still have a few minutes.
Yes, I just wanted to ask the panelists, so one of the huge losses of Section 5 not being operational is the fact that you don't have states required to give notice when they're going to do a voting change, so people can look at it and determine whether in fact it's going to have any kind of adverse impact. And under that requirement, the state actually had to do its own analysis to make sure it wasn't inadvertently doing something like that. Do you know of many states who are either have laws or are voluntarily providing notice in enough advance of a change going into effect? I believe like South Carolina may have passed something a couple of years ago, but I'm wondering if you're aware of how many states actually do that.
What specific change are you talking about in the voter activity,
so
voter
you were-
registration?
Yeah, so under Section 5, with 4 coverage, right? If you were covered, you had to say if you were going to close a polling site or move it or, change a registration rule or many of the things that happen that don't make the newspapers because they're seen as administrative, but as we had a witness testify from Alaska, can be a big deal if you're combining 2 polling places that aren't connected by any road. And so to vote, you would actually have to fly to the polling place at great expense. So I'm just wondering, how, because as Mr. Pitts just said, a lot of this happens on the local level. How can we be tracking exactly what's going on?
One of the things that we have encouraged, and we can't mandate, but this is supposed to be done, is that whenever that occurs in any local municipality or county community that affects those voters, they're supposed to be properly notified. And we do encourage that to be done directly through specific contact with those voters. That does not always occur. There's not always stories that are in the local newspaper or on the local TV or radio stations. And that's disappointing because anytime it affects a group of people, it adds to the inconvenience or the anxiety or any number of other concerns that they could have when they're going to exercise their right to vote. So we need more education when it comes to that. That's also part of what the resources from the Help America Vote Act could be used for. If a community says, we don't actually have the resources to be able to do that, that should not be an excuse.
Yeah, so you don't have like a state website where, and
Yes,
ask
ma'am,
all
but- yes,
the
ma'am, but-
local,
yes, ma'am, but-
ask all your local election
Yes,
officials.
ma'am, because we don't have a list in Montgomery
Mhm.
of all the polling places throughout all 67 counties. Each local county has that, so they know where to go, but we don't have a master list for people to gain access to.
No, I was thinking more of, I think what South Carolina does
Yes,
is they require local election officials, if they are going to make any kind of change within certain amount of days of an election, they have to put it up on the state website so that people know.
Yes,
and
ma'am,
can
because we're
give
not always
feedback.
notified, but one of the things that we do now with our system, our electronic system I was mentioning earlier, where people can register, is if you put your name in Bayou, La Batterie, or wherever you happen to be, and you can find out where you vote and if it has been changed, and that is automatically updated.
And I just wanted to let you know, there is a system that was created by Pew that does actually can check voter registrations against a number of lists with other states to
Yes,
make
ma'am,
sure.
and we're a member of
Right,
that.
right.
The
And then
Electronic
they-
Registration
and then
Information Center.
They
and
actually have the ability to
cross-check.
tell you which of your people probably should be registered to vote who aren't.
Yes,
Right.
ma'am, and we're using that too. Thank you so much.
Thank you to this excellent panel. We look forward to, I'm sorry, Ms. Bishop, do you want to have just the last word?
I wanted to add something very quickly to that conversation, that even in the case of laws that require notification for voters be put up on state and local government websites, that those websites are often not compliant with federal accessibility law, and that that's something that should be looked at or that could be addressed in a fully restored Voting Rights Act. Thank you.
Thank you. Thank you again to this powerful panel. We'll take a 10-minute break and be back for our final panel of the day at 3 p.m. For those who can hear me and who are interested, the second comment period sign up is now in the next room. Okay, we're ready for our final panel of the day. Thank you. In the order in which our panelists on this fourth panel will speak, they are John J. Park Jr., counsel at Strickland, Brockington, Lewis, LLP; Judd Choate, president of the National Association of State Election Directors and election director of the state of Colorado; Dale Ho, director of the Voting Rights Project at the ACLU; Lorraine Minnight, professor of political science at Rutgers University; Jerry Vadamala, director of the Democracy Program at ALDEF; and Tomas Lopez, executive director at Democracy North Carolina. Mr. Park, please begin.
Madam Chair, members of the commission, thank you for this opportunity to speak. What I'd like to do today is deviate from my written remarks and address something, because a lot of this has just been focused on Section 5, and what I'd like to suggest that if Section 5 is renewed, serious consideration be given to taking redistricting out of it. I'd start by noting that the Voting Rights Act was meant to address race, not politics. President Lyndon Johnson focused on ending practical barriers to minority voting, which he identified and divided into three categories: technical, that is, poll taxes; non-cooperation; and subjective, literacy tests. That's in his message to the United States related to the right to vote in 1965. When he spoke to a special joint session of Congress, President Johnson observed, "We meet here tonight as Americans, not as Democrats or Republicans. We meet here as Americans to solve that problem of assuring equal rights for African Americans when they went to vote." And the commission should heed President Johnson's exhortation and refrain from doing political work for one side or another. And the redistricting process is an inherently political process. And it gets justice involved in doing work for one party or another. You start with the fact that it has a limited scope. What the Justice Department looked at was a benchmark plan, and it compared the number of minority-majority districts in the benchmark plan to the new plan. And if you came in at the right number, the plan should be pre-cleared. Maybe a state should draw more. Well, that's a Section 2 problem. And you look at whether there is a compact, contiguous group of minority citizens that is large enough to form a majority in a single-member district. But it's a separate inquiry. The Department of Justice voting section in the pre-clearance process wasn't supposed to insist on drawing more districts. And the pre-clearance process is not designed to insist on drawing more minority-majority districts. But that's exactly what happened in Miller versus Johnson. The Department of Justice insisted that Georgia draw a third black majority congressional district. And North Carolina, the benchmark was 2, and the Supreme Court reversed, said the drawing of a plan that united Atlanta suburbs with the coast was an unconstitutional racial gerrymander. And the United States paid some $600,000 to the successful plaintiffs in that case. And that's not the only case in which that happened. If you go to in Harris versus Arizona Independent Redistricting Commission, that case came before that disputes arising out of that commission's work came to the court twice a couple of years ago. Their advisors to the Arizona Commission told the commission that the Voting Rights Act required minority-majority districts to be underpopulated in order to obtain preclearance. This led to the creation of 10 minority ability to elect districts, where 7 was the benchmark number. It's fine, in my judgment, to create such districts when Section 2 requires it, or if you want to do it for political reasons. But it's not fine to do that under the guise of Section 5. And when we think about it, Section 2 of the Voting Rights Act calls for an equal opportunity, not a greater opportunity, using the pre-clearance process to give an advantage to minority citizens by underpopulating their districts and overpopulating others is inconsistent with Section 2. And to the extent that was political work, the Voting Rights Act is not designed to benefit one political party over another. Another point I'd make is that it's of limited effect. You get a preclearance letter, that doesn't immunize a state from being sued under Section 2 or under the Constitution. Alabama Legislative Black Caucus, that case is indicative of that. Alabama's plans were pre-cleared. That did them no good when they got to the Supreme Court and the court said the plans were racially gerrymandered. It took a separate lawsuit, and what the department did, what Alabama did was we drafted, the plans were drafted with the Department of Justice's guidance in mind. The department said that a comparison of the census population in the benchmark districts and the proposed plans is the important starting point of any Section 5 analysis. Obviously, more is required, and the state's preclearance submissions did not stop there. So the point is that the preclearance letter didn't give much comfort to Alabama. The last point, political point I'll make is that go back to Kinston, North Carolina. My understanding is that Kinston's black majority. In 2008, almost 2/3 of the voters of Kinston approved a referendum making local elections nonpartisan. And that approach is consistent with what almost 100% of North Carolina's municipalities use. But the Justice Department got it in its head to deny preclearance of that. And it thought that minority voters wouldn't know which candidate to vote for if they didn't have a party name next to the name on the ballot. And that's just patronizing, and it's wrong, and it shouldn't be part of the Section 5 review process. Thank you very much.
Thank you, Mr. Park. Mr. Choate.
Madam Chair, Commissioners, thank you very much for inviting me here today. I think I'm your only elections professional. I'm certainly your only bureaucrat that you're going to hear from today. I take the label of bureaucrat as the highest praise that you can get because unlike some of the ways in which it's been disparaged today, I don't have a constituency other than the entire state of Colorado. I don't have a group of people who voted for me and a group of people that voted against me. I don't have people who read my magazine and people that don't read my magazine. I don't have people who support my point of view or fund my organization. I do what's best for all the people that live in my state. So, and I'm also very happy to be on this panel because frankly, the other panels have been kind of depressing. I like the idea of being on the panel that talks about what we can do now that we're in a post-Shelby environment. So let me kind of speak to some of those. I'm going to make a radical proposition to you. I'm going to tell you that I don't believe that 4B is coming back, and I don't think that we're going to have preclearance anymore after Shelby. So what can we do within federal law to shift to a new perspective on access? And we do have some opportunities there because elections are constructed around two different principles. There's two main elements of elections. There's the voting element, which the Voting Rights Act has sort of focused, the litigation around Voting Rights Act has focused on actual voting at the polls. But there's also an incredibly important part of elections, which is really not traditionally thought of in the realm of the Voting Rights Act, which is registration. And we do have a federal law, a pretty recent federal law in the last 25 years that deals with voter registration, and that's the motor voter, the MVRA, the National Voter Registration Act. And the MVRA is very underutilized. It has language in it which supports pretty significant different ways of thinking about voter registration, which currently are not part of the public conversation about elections. So what is motor voter? It was passed in 1993. It became law in 1994. It links driver's license applications to voter applications, and it has specific language in it which encourages the registration of those who apply for a driver's license or a state ID. So I'm your only PowerPoint person of the day, but if you should have a document, but I also have a PowerPoint, and I'm going to show you the specific language of the MVRA. So this is 55 USC 20504. This is the actual language out of that piece of statute, and it's called simultaneous application for voter registration and application for motor vehicle driver's license. So that's not my language, that's the language straight out of the statute. And I'm going to read part of it to you, and it says, each state motor vehicle driver's license application shall serve as an application for voter registration. And that comes right after it said simultaneous. So the way I read that, and I think the way any kind of reasonable attorney would read that, is that when you apply for a driver's license, you are simultaneously applying for a voter registration. So you are registering to vote at the same time you are registering for a driver's license. So what does that mean in practical application? Well, in practical application, that means that that every person that applies for a driver's license, or by extension, a state ID, should be registering to vote. And that's what you kind of euphemistically we call automatic voter registration. Automatic voter registration has been written into the law for the last 25 years, but we haven't been doing it. So there is a broader way to read the MVRA that hasn't been applied in the majority of US states. It was first applied in 2014 in Oregon when they created an automatic voter registration law. It's kind of a complicated law, and other states haven't adopted it, but there are a handful of states, Colorado included, who have adopted automatic voter registration in a sort of more streamlined way that doesn't require the sort of the follow-up contact. But voter registration should be a part of somebody's interaction at a driver's license bureau. And by the way, you might be asking, well, what happens when I'm already registered or I already have a driver's license? Well, they have a section for that in the MVRA as well. Any change for address form shall serve as notification of change of address for voter registration. So if you already have a driver's license and you're already registered to vote and you make a change to your driver's license, it should reflect simultaneously as a update to your voter registration. That would take care of the lion's share of voter registration problems that we have in the United States, and it would help to increase the number of people who are registered to vote. Colorado has the highest percentage of registration of eligible population in the country at almost 90%, 89.4%. It's one of the reasons why is because we do this. Another reason is because we're in ERIC, which was referenced earlier, the Electronic Registration Information Center. The MVRA is a really underutilized part of our federal statute, which could really drive that percentage up. The pre-clearance states, so the sort of traditional southern states, all the way to Arizona, skipping New Mexico, have some of the lowest percentages of registration in the country. And if they adopted a reading of the MVRA, which is clearly the language of the MVRA, or if somebody really encouraged them to do that, say by, I don't know, filing a lawsuit, they might very well drive up their percentage registration, and many of the downstream problems that occur in a polling place would be mitigated by the fact that they were registered and properly registered, and that information was updated on a routine basis. So I don't believe Shelby is going anywhere, so let's go around it. Let's make sure that everyone is registered using the MVRA's already existing language, and let's give populations various ways to vote. Colorado does mail voting for the most part, and that's another way that you can get around some of the polling place issues. Thank you.
Thank you very much. Mr. Ho?
Chair Lehman, members of the commission, thank you very much for holding this hearing today and for inviting me to testify. My name is Dale Ho, and I'm the director of the ACLU Voting Rights Project. The right to vote is the cornerstone of our democracy, and we seek to protect it on equal terms for all Americans. But that right is today under siege. Almost immediately after Shelby County, 7 states that were formerly covered by Section 5 enacted or implemented laws or administrative practices that restricted either voting or registration. In addition to these statewide changes, a study by the Leadership Conference on Civil and Human Rights of 381 counties that were formerly covered by Section 5 found that about 43% had reduced the number of polling locations, with a total of 868 polling place closures in those counties alone. Successful Section 2 litigation has been a ray of light in states like Texas and North Carolina, but these cases put in stark relief what has been lost with the demise of the preclearance system. Litigation has been costly and has taken years, and in the meantime, despite motions for preliminary injunctions in these cases, several of which were actually granted, multiple elections were held in these states under rules that courts ultimately determined were intentionally discriminatory and thus unconstitutional. So simply put, since the Shelby County decision, we have a record of constitutional violations necessitating a congressional remedy. There are 2 bipartisan proposals that seek to fill this gap: the Voting Rights Amendments Act and the Voting Rights Advancement Act, each of which would address the gaps that we now have by subjecting states and other jurisdictions with recent voting rights violations to federal preclearance. Now, in the meantime, the Department of Justice has engaged in some commendable work to enforce Section 2, but it could have been doing and could be doing much more in that regard. Its voting section dwarfs the ACLU's Voting Rights Project, which I direct, but it has brought fewer Section 2 cases since Shelby County than we have. And unfortunately, there are signs that DOJ may be turning away from its historic mission of promoting voter access. Now, in addition to abandoning its positions in voting rights litigation out of Texas and Ohio, last year, DOJ requested information on list maintenance practices from 44 states. A sweeping inquiry that the former head of DOJ's Civil Rights Division, who testified earlier today, Vanita Gupta, described as virtually unprecedented. The timing of this request was also suspect, coming on the same day as an infamous demand by the now defunct Presidential Commission on Election Integrity for all 50 states' voter rolls. Now, one of my colleagues on this panel, Mr. Park, has suggested in his written remarks that DOJ should actually be encouraging states to engage in more robust purging of their voter rolls. And he referenced DOJ's opposition to a voter purge program in Florida. And with all due respect to Mr. Park, I think Florida actually represents a cautionary tale about inaccurate and overzealous purging. Now, in 2012, Florida officials claimed that nearly 200,000 registered voters in the state may not be U.S. citizens, but that number shrunk dramatically, with the Secretary of State's office sending a list of about 2,700 possible non-citizens on the voter rolls to county supervisors of elections. But even that figure collapsed under scrutiny. PolitiFact confirmed that a total of only 85 non-citizens were ultimately removed from the rolls in a state of more than 11 million registered voters. So we're talking about 0.00077% of the registered voters in the state. Now, meanwhile, while all this was happening, thousands of US citizens were wrongfully designated as non-citizens and threatened with removal from the rolls. And one was a Brooklyn-born man named Bill Internicola, a World War II veteran who had fought at the Battle of the Bulge. Now, an analysis conducted by the Miami Herald indicated that about 87% of those identified by the state as non-citizens on the rolls were minorities, and 58% were Hispanic. So there was a racial disproportionality that went along with this inaccurate system. The U.S. Court of Appeals for the 11th Circuit ultimately held that legitimate voters in Florida, quote, face a realistic danger of being identified in the Secretary's removal programs because of their names or status as naturalized citizens, end quote, and ultimately ordered a halt to the purge. You've also heard a few comments today about the interstate voter registration cross-check system, which purports to compare voter rolls across states. A team of researchers at Stanford, Harvard, the University of Pennsylvania, and Microsoft took a look at cross-check and found that it misidentifies supposed double voters about 99% of the time. Now, I went to law school in part because I'm not very good at math, but that sounds like not a very accurate system to me. Crosscheck's user manual itself even states that a significant number of double voters are false positives. And in recent weeks, there have been nonstop revelations about significant lapses in Crosscheck's data security protocols and practices. 8 states, most recently Kentucky, have therefore dropped out of the program. Now, to be clear, I agree with the goal that we keep voter rolls up to date and focus on reforms that improve turnout. And the simplest way to facilitate both goals is to do what Dr. Choate referenced, which is to encourage automatic voter registration, which updates the rolls when voters move. It's an innovation that both maintains accuracy and helps voters participate without unnecessary bureaucratic headaches. As Dr. Choate noted, Oregon was the first state to adopt a system like this. It saw its turnout increase by 4 percentage points between the 2012 and 2016 elections. That's the largest increase of any state in the country. The largest turnout increases in Oregon were among voters of color. Now, between the novel interpretation of the NVRA that we heard about moments ago and Senator Leahy's proposed legislation S. 1353 on automatic registration, we have multiple options to take this experiment nationally. Now, in sum, our democracy is more vibrant and more truly representative when more Americans participate. DOJ can do its part by engaging in vigorous enforcement of the VRA and the NVRA, and Congress can facilitate that work by passing legislation that would restore the preclearance process and boost participation more broadly by encouraging automatic registration. Thank you again for the opportunity to testify today, and I look forward to discussing your questions with you.
Thank you, Mr. Ho. Professor Midnight?
Yes. Thank you very much to the commission for inviting me to testify. My name is Lorraine Miniti. I'm an associate professor of public policy at Rutgers University in Camden, and I'm trained as a political scientist. And I want to say, of course, that my views are my own and not those of my employer. I also want to flag that I have to leave a little early, but I'm very happy to answer any questions that you have by email or however we can do that. So I think in my testimony, I cited many of the examples that have already been given about what has happened since Shelby County with respect to changes in laws that have ramped up restrictions to voting rights in the last 4.5 years. And I don't want to rehash all of those examples. I might add that Arizona is a state we haven't said much about, enacted a new rule that makes it a felony to collect and turn in another person's absentee ballot, even if the person grants permission to do so. There are a few exceptions to that. But in addition, another study found that, quote, by sheer numbers and scale, Arizona is the leading closer of polling places in the aftermath of Shelby, with every county eliminating polling places, most on a massive scale. These are the kinds of changes, again, that other people have pointed to, the sort of on-the-ground, granular kinds of changes that might not show up, especially if there's no litigation challenging them, that would have been blocked in the past under preclearance. So I've written in my testimony that I focus specifically on how the loss of preclearance expands opportunities for imposing partisan-motivated restrictions on minority access to the ballot, which is a commonplace in U.S. electoral history that I have written about in a book called Keeping Down the Black Vote, Race and the Demobilization of American Voters. And there, my co-authors and I analyze U.S. electoral history, explain the political and partisan logic of voter suppression, and argue that restrictions intensify when elections are hotly contested and when operatives feel minorities will play a decisive role in the outcomes. Historically, as we document in the book, both of the two major political parties have engaged in efforts to win elections by suppressing minority votes. Importantly, they have done so by advancing electoral rules that disproportionately harm minority voters under the false pretense of combating voter fraud, which is a major focus of my scholarly research for the last 15 years. And in preparing my testimony, I tried to answer the questions that you put before me, but I think perhaps my contribution could be
from the research that I've done on the incidence of voter fraud and the uses of false allegations of voter fraud to then justify the kinds of laws that restrict access to the ballot, especially for minority voters. I say that if the past is any indicator of the future, the loss of Section 5, which once blocked racially targeted voter suppression efforts, means that hundreds of potentially racially discriminatory changes to state election laws, some of them justified as protections against alleged voter fraud, will go forward. And the only recourse, as you've heard from many of the litigators who've testified before you, is to challenge them on a case-by-case basis and only after they have been implemented and caused harm to minority voters. Thus, flagging one of my simple recommendations for the Justice Department, or for you, I guess, in thinking about this. The Justice Department must use all of the remaining tools at its disposal as provided for in federal election and federal voting laws, including the Voting Rights Act, the National Voter Registration Act, the Uniform and Overseas Citizen Absentee Voting Act, the Voting Accessibility for Elderly and Handicapped Act, and the Help America Vote Act, to protect against efforts to suppress minority voter access to the ballot through avenues that have now opened up with the elimination of preclearance, and specifically the crafting of new voter registration and voter identification rules that place a disproportionate cost of compliance on minority and low-income voters, polling place closures and relocations, cutbacks in the accessibility of early voting opportunities, restrictions on means and methods of voter assistance, and restrictions on community organizations and other organized activities to promote voter registration and voting. Now, in calling on the Justice Department to oversee and correct partisan influence efforts to restrict access to the ballot, we must be realistic. The same politics that motivates efforts to exclude certain voters with almost surgical precision, as you have heard from the Fourth Circuit Court of Appeals decision, can also infect the nation's highest law enforcement agency. Experience teaches us this. One cause for worry is the new administration and President Trump's unsupported allegation that he lost the popular vote because 3 to 5 million votes were cast illegally and implausibly, all against him. The president's bizarre allegation raises grave concerns about the current priorities guiding his Attorney General and Justice Department in its voter access and voting rights work. Now, I have no direct knowledge of what the policy discussions are inside the Justice Department, but we can look at some dramatic examples that also have been noted and mentioned in support of, first supporting voters' challenges to new restrictive voter identification rules or aggressive voter list purging, and then changing that position. The tethering of party and racial divisions could drive the Justice Department in a direction that is not just neutral or even neglecting of the protections still needed by minority voters. It could motivate law enforcement decision-making toward a hostile stance regarding the expansion of voter access and the protection of minority voting rights, in which law enforcement is used to facilitate voter suppression through the intimidation of Black voters and voting rights activists in the name of rooting out voter fraud. And I detailed in my written testimony 2 examples of that. One as recent as 10 years ago. So to sum up, I said that one of my recommendations was that the Justice Department should use existing legal tools to promote registration and voting. The second recommendation is that the Justice Department should vigorously challenge rules that restrict access to the ballot when they are justified as protections against voter fraud in the absence of a documented problem with fraudulent voters. Thank you very much.
Thank you, Professor Manite, and I deeply apologize for mispronouncing your name. I'm sure you can imagine with a name like mine, I'm very sympathetic. So I apologize. I'll ask my fellow commissioners who have questions for you to foreground those, given your time also. Go ahead, Mr. Dalamo.
Thank you, Madam Chairwoman and Commissioners. I think it's very important that you have invited our organization, the Asian American Legal Defense and Education Fund, here. It's important to have the Asian American voice included because oftentimes we are ignored. I am the director of the Democracy Program at ALDEF. ALDEF was founded in 1974. We're headquartered in New York, but we are a national organization. We seek to protect the civil rights of Asian Americans through litigation, community education, organizing, and advocacy. In my testimony, you saw I listed out some of the past discrimination and historic discrimination against Asian Americans. Many people are aware of the Chinese Exclusion Act of 1882, prohibiting immigration and naturalization of Chinese immigrants. But many people aren't aware that that was not repealed until 1943, which is not that long ago. Indian and Filipino immigrants could not naturalize until 1946, and Korean and all other Asian immigrants could not naturalize until 1952, which is really not that long ago. And we could not immigrate to this country until, many of us, not until after the Immigration Act in 1965. And I've also outlined a bunch of other discrimination and historic discrimination that has prevented us from being included in the electoral process in my testimony. ALDEF has conducted a national Asian American exit poll and poll monitoring program since 1988. There's a few reasons for that. One of them is that Asian Americans are often ignored from the political discourse, and that translates into us being ignored by elected officials. But we also implemented this program to document voting barriers that Asian Americans face on Election Day. We have our volunteers trained before Election Day to identify voting problems, and we are stationed outside of poll sites to approach Asian American voters after they've voted or have been denied the right to vote. In 2016, we surveyed almost 14,000 Asian American voters in 14 states and Washington, D.C. As consistent with prior elections, hundreds of Asian American voters were required to prove their citizenship before they were able to vote. Literally, we had interactions with voters that said they were told by poll workers, "You don't look like an American. Prove that you're an American to me." And most people do not go to the poll site with any proof of citizenship. People don't walk around with their passport, naturalization certificate, or birth certificate. We've also had experiences where Asian American voters are disproportionately required to provide ID, where they're the only ones being asked for ID and other voters are not. And that's included in reports that are attached to my testimony. We've seen numerous violations of Section 203, required language assistance not being implemented. Section 208, where voters are being prevented from assistance from a person of their choice inside the voting booth. And we've also even seen segregated voting lines. Right? In 2012 in Annandale, Virginia, Asian American voters were segregated into a Korean line, and all other voters got to vote on another line. Korean voters had to wait until all other voters were done voting. It's not the first time we've seen that. In 2004, in Boston's Chinatown, there was a Chinese voting line and a line for everybody else. We intervened in a federal lawsuit there, US v. Boston in 2006, and were able to achieve a consent decree where the city of Boston was required to provide Chinese and Vietnamese language assistance going forward. But these violations were happening every major election. We're talking about Shelby County. There's been a lot of talk today about southern states being targeted. Well, New York City was covered under Section 5. 3 boroughs, the Bronx, Manhattan, and Brooklyn were covered under Section 5. And we also had coverage under Section 203 for Asian languages. So in these jurisdictions where you had double coverage, Section 5 and Section 203, it was a valuable tool to protect Asian American voters. Through our exit polls, we've seen that just about a third, sometimes even more, Asian American voters are limited English proficient. These are American citizens that are eligible to vote, but many of them require language assistance. Through Section 5, we were able to require the New York City Board of Elections to fully translate the ballot into Chinese. In 1990, when Chinese was covered, the New York City Board of Elections said it could not do the translations because it would not fit on the machine ballots. We were able to show them that it could fit, and once it was translated, they said, well, we can't transliterate the candidates' names. Only because of Section 5 and the DOJ at the time interposing an objection, that required the city to fully translate the ballot, including transliterating candidates' names, allowing 55,000 limited English proficient Chinese American voters to be able to cast a ballot. In my testimony, I also outline other ways we use Section 5 in New York City to protect Asian American voters. Poll site moves, and after 2001 in the terrorist attack of 9/11, a poll site was contemplating being moved without any notice to the community, only because of Section 5 and a request for more information was that poll site required to stay and people in the community allowed to cast a ballot. Changes in methodology for school board elections, changing in targeting methodology, all those things were prevented from happening and hurting Asian American voters because of Section 5. And again, I want to be clear, Section 5 did not only protect African American voters in the South. It was protecting Asian American voters in New York City, and it was very powerful. And it's a real shame that we don't have that protection right now, because we still need the protections. In 2013, just a week after Shelby County, we sued the New York City Board of Elections for not translating the ballots into Bengali in Queens County, which was required under Section 203. The New York City Board of Elections simply did not do it. We had to sue them. And we don't have the notice, this was mentioned earlier, we don't have the notice of violations of Section 203 and Section 208 that we may have had when we had Shelby County, but prior to Shelby County. We have to do these, work with community-based organizations and receive the notice from them, or be apprised of it ourselves to be aware of it and litigate these cases. We sued the state of Texas after the 2014 midterm elections for violating Section 208 of the Voting Rights Act, which allows you to bring somebody of your choice inside the voting booth as long as it's not your boss or union rep. It's a very simple provision. States just need to get out of the way and allow an LEP voter or a voter that has disability to be assisted by a person of their choice. They couldn't even comply with that. They fought us tooth and nail at the district court. We won there, and we won at the Fifth Circuit Court of Appeals. We had asked the DOJ to be involved early on. They were not. We were pleased to see that they did submit an amicus brief at the Fifth Circuit level, but we need more assistance from the DOJ in bringing 203 and 208 cases, because it's sorely needed. And we do support the Voting Rights Amendment Act and Voting Rights Advancement Act, because it will give us some coverage, and we currently have no coverage, and that's just simply unacceptable. Thank you.
Thank you, Mr. Batamala. Mr. Lopez.
Good afternoon, Madam Chair and Commissioners. Thank you for being here and for having me. I am mindful that I'm the last panelist on the last panel of a full day. My name is Tomas Lopez, and I'm the Executive Director of Democracy North Carolina. We are a nonpartisan organization that uses research, organizing, and advocacy to improve voter access and reduce the negative influence of money in North Carolina's political system. Immediately prior to joining this organization, I was an attorney at the Brennan Center for Justice at NYU School of Law, a national organization with which I litigated federal voting rights cases, advanced state-level legislation, and participated in election law and administration research. Pre-clearance and robust federal oversight serve deterrent, prophylactic, and remedial functions together, and they are together needed to protect the right to vote at the state, local, and individual levels. North Carolina is a telling example of how their loss affects all three. Other witnesses today have discussed the statewide impacts, and in particular, H589 and the Fourth Circuit's holding in that case. I will use my time to highlight the local and the individual. First, the local. Pre-clearance covered thousands of counties and local jurisdictions, including 40 counties in North Carolina, where boards of elections hold substantial authority over voter access through, among other things, polling sites and early voting hours. From the 2016 election, I would highlight dramatic reductions in early voting hours in several counties, including Guilford, which lost 660 hours of early voting across all its sites, Mecklenburg, the largest county in the state, losing 282 hours, Brunswick losing 165, Craven losing 141, Johnston losing 124, Robeson losing 121, and Jackson losing 113. Of these, Guilford, Craven, and Robeson were previously covered under Section 5, and Mecklenburg and Johnston have significant Black voting populations, which as of 2016 were 33 and 16% of all registered voters in those counties, respectively. Second, I want to address the individual level. Our research agenda, Democracy North Carolina, reports on, among other issues, how individual citizens experience voting during early voting and on election day. And that's a perspective that I want to make sure is represented on these panels. With our work with the Nonpartisan Election Protection Coalition, we help lead efforts in the state to monitor that experience, to assist voters when they have issues and analyze them when reported. And what voters reported to us in 2016 and in 2014 before that was an environment with renewed intimidation. I will share some examples as reported again to this organization and to the press. In Johnston County, a man was followed around by a polling place worker until he cast his ballot, and the poll worker then told him when he was asked why he was being followed that, quote, things had changed. In a formerly covered county, Wayne County, a local African-American voter and local party official had was assisting an elderly voter at the County Board of Elections when they reported that the elections director yelled at her for assisting voters, called her a troublemaker, and told her not to come back as she was leaving. This person told the local paper that the director told the local paper that he was correcting the woman's overreach and offering assistance, and that's a claim that the complainant denied. In 2016, in Pamlico County, an elderly white party volunteer was handing out literature outside the County Board of Elections early voting site. A young man approached her and asked if she had a handicap sticker for her car. When she responded that she did not, he shoved her down and told her that she would, quote, if Hillary wins. She suffered minor scrapes, but did not want to press charges. Finally, on Election Day in 2016, in that same county, a caller reported driving past the Bayboro precinct, the same location as the County Board of Elections office, the only early voting site in that county also, and seeing a black truck with individuals holding a candidate sign saying, go home, N-words, slurs, the candidate will send you back to Africa, and then driving off. In 2016, 43% of the registered voters in that district were African American. Now, pre-clearance would not necessarily have stopped these individuals. We're clear about that. These are individual reports, but they're part of a pattern. And I would urge the commission to consider that law acts not only through its express functions, but in what it expresses to the general public. The failure to date to restore pre-clearance and the recent retreat, as my fellow panelists mentioned, in federal voting rights oversight expresses the same message, that voter access is simply not a priority for the United States. That empowers people who would cross lines. It goes towards silencing others. That is true here and in the nation at large, and speaks to the need to restore the full protections of both the VRA and its enforcement structure. Now, as far as details as how to do this, I would again echo my fellow panelists who point to the legislation that has been presented to Congress. I think these are things that one of my earlier witnesses, I think it was Mr. Rosenberg, discussed how frankly we're in a position where we would like this to be discussed. We understand this is something that will have to be hashed out. I'll also add that I appreciate the reminder from Secretary Choate and others that our voting rights enforcement infrastructure is more than just the Voting Rights Act. It's the MVRA, it's UACAVA, it's HAVA, it's the ADA. And I would urge this commission, considering what to do in terms of presenting solutions moving forward, to keep that in mind as well. Thank you.
Thank you, Mr. Lopez. I'll open up the panel for discussion. Commissioner Yaki.
Thank you very much. First, on behalf of the chair and myself, I'd like to say hello to all the Yale alumni on the panel. There are three of you, and it's good to see that we are overrepresented, as we always are, in non-traditional fields of study. So I have a question for Mr. Ho and Mr. Lopez, not just because you're both from Yale Law School, but when it comes to either the Voting Rights Amendments or the Voting Rights Advancement Act, which one do you think now best fits the situation that you're seeing in terms of the state of litigation and the state of play with regard to the problems that you see post-Shelby? Why don't we start with you, and I'll go with.
Thank you for the question, Commissioner Yaki. Either act would be a vast improvement over what we have today, because both acts would restore the pre-clearance process. Now, one thing that I noted in my written submission to the commission that I think is valuable about both acts is that they establish pre-clearance based on voting rights violations of various kinds in recent years. So, for instance, sometimes we talk about Section 2 litigation and comparing the states that have more Section 2 litigation versus those that don't. That's a useful way, I think, of starting to try to understand the problem of where voting rights violations are more frequent, but it doesn't capture everything, right? There are lots of kinds of violations under the National Voter Registration Act, under Section 203 and 208, there are constitutional claims for racial gerrymandering. We've seen cases out of North Carolina, Virginia, and Alabama that aren't captured when we look just exclusively at Section 2 cases. So both acts have the benefit of casting a broader net. I would say of the two, the Voting Rights Advancement Act is the more, provides for more robust protections. It subjects jurisdictions to pre-clearance based on violations during a slightly longer period of time than the Voting Rights Amendments Act. Most recently in 2015, the Advancement Act was co-sponsored by Senator Murkowski in Alaska, so it has had bipartisan support at times in Congress, and of the two acts, I think it provides the stronger protections.
I would echo Mr. Ho's comments. I would also say that Democracy North Carolina, to my knowledge, has not formally endorsed either one of these, and so I wouldn't want to go into too much detail except to say that we want enforcement that is robust as possible, and also takes into account recent violations like those that we've seen in North Carolina.
Just a quick question from Mr. Choate. A panelist before you drew some example of the pairing of voter registration and driver's licenses and alleged essentially that there could be abuse in that situation. Could you respond to that?
Yeah, you mean from a non-citizen perspective? So, so I can speak to Colorado, and I think I can speak generally about the Real ID states, which is not every state. But in Colorado, in order to get a driver's license, you have to supply 2 forms of ID that are, very high bars. Either a previously issued driver's license from another state, a passport, a birth certificate, some combination of those elements. So if you don't produce those in Colorado, and I think in all the other Real ID states, they would take note of the fact that you didn't supply those, and in our regime, they put there's a column in the information we received from the Department of Revenue from our DMV that lists the documents that they did show, and those are typically either a travel visa, a work visa, a marriage visa, a green card, and we get those codes, and so we can see that somebody is not eligible, and we have it built into our online voter registration system. So if you try to register online and that happens, you're going to get rejected. And then we also do a monthly review where we take our entire voter registration list and we run it up against the DMV list with that column. And if anybody comes out as having registered in the last 30 days that has one of these elements in that column, we ask them, hey, did you mean to do this? Did you mean to register? And in many cases, they say, yes, I did mean to register because I'm a US citizen now. And only rarely is it the case that they're not a US citizen. So it actually, often somebody will show a document when they're getting their driver's license, which is a document which suggests that they're not a US citizen, or they did that in 2012 and subsequently they become a US citizen. And so often that's where the hangup is, that's where the confusion comes. But there are very few people in our review of our lists that are not US citizens who are registered to vote.
Thank you. Commissioner Arasaki?
Mr. Lopez, in a lot of states after Shelby passed, I know that there are community-based organizations such as yours set up efforts to be able to monitor boards of elections or whatever that kind of grouping is in the particular state. Did that happen in North Carolina, and how much work has that been, and how important has that been in terms of replacing the fact that there's now no notice requirement because there's no Section 5 application?
Thank you for raising that question, Commissioner. We've devoted considerable resources on that ground level work over the last several years. As a bit of background, our organization is based in Durham, but has 5 offices around the state where we are working in some years as many as 60 of North Carolina's 100 counties. I'll share an example of our monitoring work from the 2016 election. After the Fourth Circuit's decision invalidating H589, we worked with advocates on the ground to try to add and restore early voting hours, targeting 60 counties around the state, and successfully did so in over 40 of those counties. And it was, in some cases, some very low population counties where it wasn't necessarily a large group of people that was needed to make their presence heard. And it was also the case that these are places where, in fact, without a notice requirement, the County Board of Elections may proceed with its activities without much public oversight.
If you don't mind, I'd like to
Yes,
comment on
Mr.
that.
Choate.
So under Colorado law, they have to post where a polling place is going to be prior to an election. And there is an opportunity for a member of the public to challenge where a location is. I think that's not an unusual law in state government. So one of the opportunities that's available where Shelby does pretty significant damage to the Voting Rights Act is that you can kind of incorporate some of that into your state law. And I think many states have either they formally had it before the Voting Rights Act had its Shelby decision, or they've subsequently put something like that into their law, either requiring public disclosure or even a public hearing based on the locations which are chosen for a particular election. So that's another avenue that states have, given the limitations of the Voting Rights Act now, post-Shelby, is that they can just put it in their own law.
Do you, we actually had the Secretary of State from Alabama in the panel before. Are there any associations of election officials who are actually tracking that and could provide that kind of data to our staff so that we could actually look and see?
So good question. There is an organization called NCSL, the National Center for State Legislators, which typically keeps that kind of information. Wendy Underhill is the director of the election section. She's a really good resource, and that's the kind of thing that I would ask Wendy, and I'm guessing within about 3 weeks she would have it for me. So I would recommend that you pursue that with the NCSL.
Thank you. Mr. Vadamala, you reference your litigation in about Section 208 in Texas. Can you give a little bit more specifics about what the actual issue was in terms of what Texas was not allowing that you felt was a violation?
Sure. The state of Texas had a state election law that required all interpreters to be a registered voter in the county in which they were providing their service. Section 208 has no such restriction. And this was particularly problematic for Asian American voters because, as I mentioned, there's such a high percentage of LEP voters within the Asian American electorate. And in a place like Texas, prior to 2016, only one county was covered for Asian language assistance. It's Harris County. So all other Asian American voters within the state of Texas had to rely on Section 208 for language assistance rather than 203. And lo and behold, we had a voter after their experience in 2014. She was a South Asian voter who was prevented from being assisted by her son, her adult son, because he was registered in the neighboring county where he went to school. So the law is pretty clear on its face. The state law was clear on its face that it violated Section 208. The county settled with us relatively quickly, Williamson County, but the state litigated all the way through to the Fifth Circuit, and we were successful there. The court found that it was a direct violation of Section 208.
And we had earlier testimony from some panelists today about the importance of observers. Can you talk about how that plays out in terms of your efforts to make sure that the laws are enforced for Asian Americans?
right? We're able to cover a certain amount of ground through our exit poll and poll monitoring project, but we're not able to cover every single jurisdiction that's covered for Section 203. There are jurisdictions around the country that are covered. A new list comes out every 5 years. So the last list came out in 2016. We have newly covered jurisdictions in Lowell, Massachusetts, and Malden, Massachusetts, Middlesex County, New Jersey, Fairfax County, Virginia, and Tarrant County, Texas, in addition to all the other jurisdictions that were already covered and remain covered under Section 203. It's crucial that we have observers in those other locations where we are not able to cover, because we have seen violations, signage not being put up, poll workers refusing to provide the language assistance that's required, interpreters that are not given a table or chairs to sit at, interpreters that are assigned in the wrong languages. In New York, when Chinese was covered, we had Mandarin-speaking interpreters in Chinatown where everybody spoke Cantonese. We had Cantonese interpreters in Flushing, Queens, where everybody spoke Mandarin. And they came back to us and said, well, isn't it the same thing? Right? After 2000, when Korean was covered in Queens County, we had Korean interpreters in Chinatown and Chinese interpreters in Korean-speaking neighborhoods. So we had to sue the New York City Board of Elections in 2006 for failure to comply with Section 203 for Chinese and Korean language assistance. And to this day, we have a memorandum of understanding with them connected to that litigation. So we have to have the observers there, even in places where we are, but especially in places where we're not, because we have seen the violations, they continue to happen, and they're only going to get worse.
And it's my understanding that there are several states where, in fact, unless you are a party represented or elect or something like, somehow some party officials are allowed to be actually in the polling place and observe, but everybody else has to be outside the polling place, so it's harder to actually see what's going on. Is that
Right,
correct?
yeah, it's really across the board. Some states allow us within the no electioneering zone, within the poll site, to allow us to observe, and other states, we're not allowed within the no electioneering zone. So we have to rely on voters telling us what's happening inside the poll site. That's very problematic, and it would be helpful to have a DOJ representative in there when we're not allowed inside.
Thanks. And I know next question is kind of wonky, but earlier today we had a reference to the fact that there are bailout provisions in the current Voting Rights Act. If you were covered, there were certain, if you wanted to file to get out of coverage, you had to meet certain conditions, and if you did, you could get out. Yet, obviously, the Chief Justice was very concerned in Shelby about unfairness to states that he felt maybe weren't bad actors and therefore were being unduly burdened. So I'm wondering if perhaps Dale Ho or others might have thought about what should that provision look like to try to meet the Chief Justice's concerns about that.
Well, I can speak a little bit about the bailout provision as it existed before the Shelby County decision. The bailout provision was used to bail out a number of counties before the 2006 reauthorization and afterwards. Afterwards, a state bailed out for the first time, New Hampshire. My recollection is that there had never been a denial of a bailout request prior to the Shelby County decision. So the issue does not appear to be whether or not it was unduly onerous to bail out, but whether or not bailout was being used perhaps frequently enough for jurisdictions that maybe no longer, where preclearance was no longer required. I haven't given thought today to the question of what could be done with a new bailout provision that might encourage its usage more frequently. But what I will say is that the new bills, or the bills that have been proposed to bring preclearance back, are based on a record of recent voting rights violations in particular states. So encouraging jurisdictions to bail out may have been an issue, say, in 2006 when you're reauthorizing a formula that had been previously reauthorized in 1982. But if we're starting with a new formula in 2018 or 19 or something like that, then I think encouraging jurisdictions to bail out right away, right after you've told them that they should be subjected to preclearance, may not be the most pressing issue.
And my last question is, Ms. Minity, hopefully I said that correctly. People screw up my name all the time. Is you referenced the fact that we had asked very specific questions, which may or may not have fit with a lot of the expertise you could bring to the table. I think staff would be very interested in a submission of information you have about the issue of fraud, which has come up numerous times during this hearing, and I would invite you to please submit what you think would be useful to staff, and I'm sure staff will be following up with you.
We didn't get your commitment and the transcript, and we would like it.
I will be happy to do that.
Thank you. Commissioner Degler.
Mr. Ho, a couple of questions for you. Could you explain to us the relationship, to the extent there is one, between private counsel and DOJ's enforcement efforts? So the aegis of this hearing is looking at the statutory, it's a statutory enforcement report of DOJ's Voting Rights Act enforcement. As I understand the regime, DOJ has power to bring cases, but the private bar does too. Could you help us understand the relationship between what DOJ does and what the private bar does, and how the statute overall is enforced?
Well, both the Voting Rights Act and the National Voter Registration Act and other federal voting rights protections contemplate both that the Department of Justice will bring enforcement actions, but also create private rights of action for private citizens represented by their own attorneys to bring actions to enforce those protections. Now, DOJ is tasked with enforcing both the VRA and DOJ, and one would assume that as the agency that's led by the Attorney General, who represents the people of the United States, that DOJ would be the chief enforcer of those two statutes. The Department of Justice, however, I think has brought since 2014 a single case under the Voting Rights Act, one earlier this year, in 2017, and a single case under the National Voter Registration Act, one in my home state of New York last year.
And do you understand the private bar and the DOJ to have the same resources to apply to these efforts?
Not at all. Private citizens, voting rights cases are very expensive. We've heard this refrain numerous times. Particularly cases under Section 2 of the Voting Rights Act frequently require testimony from multiple experts. I can speak from my own experience that these cases typically run easily in six figures in terms of expert expenses alone. So for a private citizen to bear that cost, it's essentially impossible, right? It does obviously happen that private organizations like the ACLU, like the NAACP Legal Defense Fund, like the Brennan Center for Justice and the Lawyers Committee for Civil Rights and MALDEF and NARF, can bring some cases, but we do not have the resources, either in terms of the financial resources or the person power that the Department of Justice does. And I think it speaks volumes in terms of how aggressive DOJ has been in protecting voting rights when an organization like mine has brought more Section 2 cases than DOJ has in the last 5 years.
An earlier panelist suggested that preliminary injunctions in the context of Section 2 litigation and/or the 3C remedy, and very often voting lawyers speak a language that only they understand. And so there's been a great deal of talk about the 3C remedy. I'm quite sure there are about 12 people in the nation that know what that means. So if you could, we might be up to 15 because we had a lunch break. But to the extent you can you help us understand what is this mysterious 3C remedy, and are those two things, the 3C remedy and the preliminary injunction under Section 2 or a constitutional challenge, a substitute for what has been lost in Shelby?
Sure, I'd be happy to address both of those questions. Let me start with the piece on preliminary injunctions. One of the things that you hear frequently from voting rights advocates is that voting is different. I believe Justin Levitt, the former Deputy Assistant Attorney General for Civil Rights, testified to that effect earlier today. If you're discriminated against in the employment context, for example, it's obviously a terrible thing, but you can be compensated and made whole after the fact. right? If you were denied a raise or a promotion, you can get that back pay and you can get that interest and be made whole. When it comes to voting rights, that's not really the case. If an election takes place under a discriminatory or otherwise unlawful regime, there's no way to get that election back, to rerun it and vindicate your voting rights after the fact. That's one of the key reasons why preclearance was so important. Now, we heard during the Shelby County decision that maybe you don't need preclearance, or during the Shelby County oral argument, I should say, maybe we don't need preclearance anymore, which freezes the status quo and requires jurisdictions to show that their changes to voting laws are non-discriminatory before those changes go into effect. Because you can always seek a preliminary injunction in a voting rights case, right? We heard this refrain many times, both during the 2006 reauthorization and around the time of the Shelby County decision. Well, after Shelby County, we tried. We brought voting rights litigation in numerous states, places like Wisconsin, North Carolina. Other organizations brought cases in Texas. We brought a case in Ohio. In a number of these cases, preliminary injunctions were granted, yet still the litigation either took so long or the preliminary injunctions were granted too close to an election to be enforced in time for that election, that we had elections take place under regimes that were preliminarily determined to be illegal, and then subsequently on final judgments from the court, either after summary judgment or after trial, were determined to be illegal. In some cases, laws that were determined by courts to have been enacted with intentional discriminatory purpose, which is unconstitutional, and thus we had unconstitutional elections, violations that took place that went unchecked, for which there was no remedy. It was simply tough luck, right? And that's precisely why I think that record shows that preliminary relief under other provisions of the Voting Rights Act has simply been inadequate to the task, and why further congressional remedies are necessary in this context. Now, we've heard also about bail-in, your second question, Commissioner Adegbile. The 3C provision of the Voting Rights Act permits courts to order that jurisdictions that have been found to have violated the 14th or 15th Amendments to be subjected once again to the federal pre-clearance process. And it's a good thing that bail-in exists. No one, I think, would say that it's a bad idea. But I think it's important to remember that the standard for bringing a jurisdiction into pre-clearance under the bail-in provision is quite high. We have to show a constitutional violation in the form of discriminatory intent. Now, in 1982, the Voting Rights Act was amended, so we're talking about over 30 years ago, by Congress, and that amendment was signed into law by President Reagan, which created a results standard under Section 2 of the Voting Rights Act, based in part on the theory that those who would violate voting rights frequently no longer advertise their intentions, and that a results standard would be necessary in order to relieve plaintiffs of the burden of having to be mind readers and proving discriminatory intent. So for 35 years, there's been a recognition in federal law that proving discriminatory intent is an extremely high bar. And since that's the bar that you need to clear in order to obtain bail-in, it's really not something that is accessible to litigants in a way that can meet the need for greater federal supervision of voting rights.
One more for you, Mr. Ho. We've heard also a bit over the course of the day about voting changes with respect to polling places. So my question here is twofold. I think lots of people will probably believe that a change in polling place is sort of a rudimentary voting change that election officials should be able to make. And it's not immediately clear why that raises questions of voting discrimination. And so if you could help us understand, does it not? Does it depend on the context? What is the issue there? And then separately, to the extent that there may be an issue under the VRA, is Section 2 an adequate remedy to deal with that type of voting change, as opposed to a law that's going to take place over time and is advertised the way in which that type of voting change occurs?
Thank you for that question. I mean, obviously, polling places the location of polling places can change for a number of reasons. No one's suggesting that every change to a polling place, location, or closure of a polling place is in and of itself discriminatory, but it can be under certain circumstances, right? If polling places are being located less frequently in predominantly minority or low-income neighborhoods, that can impose a greater burden on voters from those neighborhoods when it comes to voting on election day. Fewer polling locations can also translate into longer lines on election day, which inures to the detriment of all voters. I think if you look at the 2016 primary, right, Arizona's Maricopa County closed a number of polling places, dozens of polling places, in a move that would certainly have been reviewed under the Section 5 pre-clearance process. And the result was routinely lines that stretched 4 or 5 hours during the primary election in 2016. So polling place closures can be a significant problem. Now, Section 2 relief isn't really adequate to the task for this for at least 2 reasons. The first is that, as I mentioned before, Section 2 litigation is quite expensive, right? You have to prove not only a discriminatory result, you have to prove a number of factors about the jurisdiction itself and the racial context of the political landscape in that jurisdiction. And, you know, I've never seen a Section 2 case brought over the decision to move or close a single polling place. The second problem is that, as I think the Arizona example demonstrates, we frequently don't learn about these problems until after the fact. You know, it was not, I think, well known that Maricopa County had reduced its polling places so dramatically before the 2016 primary. The long lines that we saw as a result happened on election day, and if a Section 2 case were brought at that time, it was too late. People already had to wait 4 or 5 hours to vote. Those who couldn't do that because of their work or family responsibilities, or simply because they couldn't stand in line for 5 hours, they lost their voting rights in that election.
Mr. Vadamala, Section 203, the language assistance provisions, they're designed to create greater access for eligible voters. That means citizens in the federal context. Can you explain to us why such a provision is important in terms of providing access to the vote?
Right, and as I mentioned, these are, and as you mentioned as well, these are American citizens that are eligible to vote. Through our exit polling, some really interesting numbers come out. More than 3/4 of all the voters that we survey, and again, the 2016, it was about 14,000 voters across 14 states and Washington, D.C. More than 3/4 were naturalized citizens, and about 1/3 are limited English proficient voters, right? And the number of first-time voters is very high. Asian Americans or Asians coming into this country, the largest segment of new immigrants, and we're the fastest growing racial group in this country. So this language assistance provision is key to allowing these American citizens the ability to cast a ballot. Otherwise, many of them would not be able to because they're not able to understand the ballot.
Last question, Professor Miniti, could you help us understand, you spoke a little bit to the fact that sometimes both parties are responsible for targeting or being found to have taken steps that affect minority voters. Today we've heard some suggestions that the Voting Rights Act is somehow unworkable because it's a vehicle of partisan warfare. I'm interested in your views about whether the Voting Rights Act is in fact a vehicle of partisan warfare or instead is a law designed to protect the civil rights of minority voters and what you understand that history to have been.
Excuse me. I think it's important to, for purposes of analysis, to separate partisan logics from the struggle for the right to vote and the history of racism and race relations in the United States. The fact that today one party may be seen to benefit, I put in quotes, from laws that try to expand access to voting, and the other party engages in pressing for laws that are seen to constrict access, means that there's an overlay of race and party, and I think people don't make the separation that they need to in looking at that. In other words, I think the Voting Rights Act is about expanding access. And my recommendation about the Justice Department enforcing laws that expand access, the metric is, does it expand access or does it restrict access on the argument that we need to do that to protect against voter fraud, because that is the frequent, common justification for these laws, for voter ID laws and other laws that are seen to restrict access. The claim is that it's needed to protect against voter fraud. Without a showing that there is voter fraud, and I would point you to look at the legislative record in every state that has recently adopted a voter ID law, you will not find that evidence entered into the record. You will not find that evidence entered into the court cases that are challenging voter ID laws either. The argument about voter fraud has been one that's been put to good partisan use. The victims of it have been racial minorities. Racial minorities, if African Americans are giving 90% of their votes to the Democratic Party, that doesn't mean they can be targeted for vote suppression as Democrats. So I think it's important to kind of try to keep two ideas in your head at the same time. One is there is a partisan logic by which both parties could try to win elections by suppressing the votes of their opponents, of the voter constituency that they perceive to be voting for their opponents. Both parties could do, that's the logic of our two-party system and the kind of electoral representative system that we have. The issue of access to the vote and the history of the suppression of votes for racial minorities has to be kept in that context. There's a partisan struggle. If African Americans are targeted, and the reason being that they're Democrats, it's just not acceptable. So I know it's a little, maybe it's complicated, and partisans have made this argument that they're not targeting African Americans, they're targeting Democrats. That's not acceptable either. I mean, just because you're a Democrat, you shouldn't be allowed to vote, But so I see the Voting Rights Act as part of the struggle for more than a century of African Americans to have the dignity of full citizenship in the United States and to have the enforcement of the 14th and the 15th Amendment in law. That's how I view what the Voting Rights Act is, that there are particular, one party benefits by expanding access and the other party benefits by constricting, has to be seen in the context of the broader issues here and the democratic norms and democratic practices that we should pay attention to. We don't have a democracy if some voters are targeted, whether they're targeted because of the party they vote for or the color of their skin. The Voting Rights Act protects people based on race and language, minority status, and so forth, not their party affiliation. But when the two come together, you can't use the fact that they're Democrats to say this is okay. We can create laws that make it harder for Democrats to vote.
May I add a few words on what Professor Minetti was
Please.
just saying? Discriminating against people on the basis of their race is prohibited by the Voting Rights Act and the Constitution, regardless of someone's ultimate motivation for doing that. There was a decision from the Ninth Circuit Court of Appeals, Garza versus County of Los Angeles, where one of the judges in that case made an analogy to the days of restrictive covenants. People may have signed restrictive covenants because they didn't want minorities in their neighborhood because they bore animus and hatred towards racial minorities. They may also have done it just because they thought that racial minorities were bad for property values. It didn't really matter why they signed the racial restrictive covenant. It constituted racial discrimination. So if legislators are targeting voters on the basis of their race, not because they hate people on the basis of their race, but because they are concerned by how those people might vote, that still constitutes racial discrimination. It's not as if there's this sort of neat line that divides race and politics, and we can say, well, this is a political issue, not a racial issue, therefore race has nothing to do with it. Race and politics have always been intertwined, and racial discrimination has always been justified in part on the basis of the policy consequences that follow from racially exclusionary policies.
Thank you.
Thanks very much. I think on that note, we will end this panel and our panels for the day. Thank you for powerful testimony again. Really appreciate it. I want to remind people that we can sign up again still for the second of the public comment periods, and all participants in the open public comment period should report back here at 5:30 p.m. to be prepared. We'll recess ourselves until 6 p.m. and for those who would like to participate in the public comment, the sign up is in the next room. Thanks very much. Thank you for all panelists.